Yes, my lord, to my lord, generally mentioned, my lord, your lordship, my lord, is taking commercial and as well as non-commercial in the arbitration matters. My lord, the non-commercial matters, my lord, will be very few. My lord, strictly speaking, will be very, very few. My lord.
The list is there. We know how many non-commercial matters are there.
My lord, but though they are, my lord, these were all filed earlier, but actually they are commercial matters, but they are appearing in the list of non-commercial. So I was playing, I'm not the non-commercial, not the commercial matters, not much more in numbers. So not if your lordship not could not give little more time to the commercial matters, and not the non-commercial not will probably need much lesser time. Not, in fact, not if the advocates are asked not to see, most of the matters will actually shift to the commercial division. Most matters.
Mr. Sinha, I'm just trying to.
Yes, I know. Your lordship is trying to assess and then. Yes.
Then we'll work it out. Probably we'll have commercial, non-commercial, 34 petitions. We'll
yes, your lordship could allocate no time for 34, 11, 9, then it will be not very, very great. Very.
But that will happen only next week.
No, your lordship, I'm sure lordship will take some time to. Very great.
Lord, this matter for extension of interim order. The due date was yesterday, my lord.
Give your slip.
Another, my lord, for inclusion in the under the execution.
Inclusion, no inclusion right now.
That was the schedule listed matter. They are running in the list matter due to change of detail.
See that, sir. Mention it next week. We'll see that. Let me just organize my board. We'll have it.
As per convenient matter may be listed. I am just handing over the slip. So bring the file and everything. It will take some time.
Give it next week. That's what I'm saying. Just give it next week. Give it on Monday. We'll take it on Monday. Give it next week.
My lord, item number 500 of your lordship's list, my lord. My lord, warrant of arrest has been issued, my lord, for non-compliance, my lord, for not filing of the affidavit of asset, my lord. If, my lord, that matter be, my lord, listed and be, my lord, the warrant, my lord, can be, my lord.
Why? You have filed your asset.
That is, my lord, ready, my lord. Any day, my lord, your petitioner, my lord, takes some, my lord, the asset will be filed, my lord.
You file it first, come back after.
My lord,
affidavit, you can always file it, right?
In the department, my lord, unless, my lord, since, my lord,
department, you can't file it.
My lord, since, my lord, my lord, kindly sees, my lord, the order, my lord. The order was, my lord, warrant of arrest issued against award data number 2. Yes. Unless, my lord, there's a specific direction, my lord, to accept, my lord, that, my lord, the affidavit of asset, my lord, this cannot be, my lord, filed in the department itself, my lord.
So let him come.
With your kind leave, your lordship, may I mention APCOM 787 of 2025. This
let him come. Let the warrant of arrest be executed. Let him come.
The mandate had.
Let him be arrested.
My lord, kindly,
let him be arrested. Let him come.
The mandate has expired on September 22, 2025. The arguments have been completed and it is fixed for final hearing, your lordship. The honorable arbitrator had communicated that some clarifications are required for passing the final award. If you can kindly list it in your lordship's list so that we can address you on the merits, your lordship.
When the matter is already pending before the arbitrator, there's some clarification. Then how can you ask for listing of the matter here?
Your lordship, we're asking.
This is a 29A application.
Extension of time.
Extension application.
The mandate has expired on 22nd of September.
All right.
May kindly
say that it's a extension of time. Give it.
Permit to mention within 29A application for the extension of the mandate of arbitrary tribunal for inclusion in the list.
Inclusion in the list. Gone out of the list.
This is a fresh application, Lordship. We have filed
fresh application.
My lord, may I be permitted to mention an execution matter? The matter has been settled between the parties for withdrawal.
Settled. Call the list.
One. Number 1,
Lordship, this is my application. Lordship, the matter has been settled between the parties. Effect. I'm handing it over to your lordship.
Learned counsel for the petitioner seeks to withdraw the present petition since the matter has been. Learned counsel for the petitioner seeks to withdraw the present petition since the matter has been amicably settled.
Lordship, those are warrant arrest.
The warrant of arrest. What is the date of that warrant of arrest?
Lordship, I'll be.
All other proceedings arising out of the.
Lordship, it's 27th August 2025. The order was passed for warrant of arrest.
All other proceedings arising out of the present EC com so and so is disposed of.
Much obliged, your lordship.
I pay for the respondent, your lordship, section 9 application.
Yes, madam.
On the last occasion, there was a direction to file affidavit, my lord, on my behalf. My affidavit is ready.
No,
But it
I am
is yet to be affirmed.
I am
It is
for the
yet to be
petitioner.
affirmed.
Yes.
I'm praying for only 2 days time, my lord.
Wait a minute. Yes. Yes.
Yes, my lord. Last occasion, the
Yes,
court is
there is-
directed to produce the document, my lord, by way of affidavit, my lord.
Yes, my lord. My
They are
affidavit
till
is
date, they
ready.
have not disclosed,
Yes,
my lord.
yes.
Order was
Affidavit is
passed, my
ready.
lord, 23rd September.
Wait a minute.
Yes, my lord.
What is the status of the matter?
My lord, the
Sold off.
vehicle has already been sold. Prior to filing of this section 9 application, the vehicle has already been sold off. I will disclose every entire document.
Including the
affidavit.
pre-sale
Yes,
notice,
yes.
my lord.
Yes,
It
my
is, that is required, my lord. The
Sorry.
pre-sale notice, before selling, my lord, the vehicles, my lord, notice is required to be served. My lord, they have not served any notice, my lord.
What is left in this petition?
Kindly fix any date on.
You don't even invoke arbitration proceedings. Don't go before the.
No, they have not served any notice, my lord. They have not served any
You have
notice.
filed a civil suit.
Not civil, my lord. 34 is, my lord, they have not served any
What
award also.
34? You have filed a civil suit also?
Yes, yes.
What
There
34
is.
you're talking about?
Yes.
Yes.
You have not even invoked 34? You don't read your brief. Learned counsel for the respondent. Section is granted. 2 days to file affidavit. As per the direction of this court, while it's order dated 23rd September 2025. Let this matter be listed on Monday.
My lord, I will file. With privilege.
Number 3, Econ 742 of 2025.
Who's there? Yeah, this was listed yesterday also, right? Who had appeared? कल भी नहीं आया था कोई? पिटिशन के लिए कोई था? नहीं था ना? None appears for the petitioner. Dismiss and default. Default.
No, this is my application. Though I had said that I had concluded my submissions yesterday, but 2 or 3 things I would like to add, my lord. But first thing, my lord, if your lordship kindly takes a look at the Arbitration Act once,
Yes. Just agree.
kindly see section 2.
Yes.
May I place it, my lord?
Yes.
This is the definition provision.
Yes.
In this part, then kindly marks this, unless the context otherwise requires.
Yes.
So it is not in my humble submission, not an omnibus, my lord, definition which would be applicable in all facts. So it's a contextual definition. Then, my lord, kindly comes to the definition of court. Now, under this 2.1, then E, court means in case of an arbitration other than international commercial arbitration, the principal civil court of original jurisdiction in a district and includes the High Court in exercise of its ordinary original civil jurisdiction. So, my lord, in my humble submission, my lord, from all the judgments which I have placed and which I shall
You
be
have placed one judgment.
I have placed one, which takes into account, my lord, various other judgments, which follows and, my lord, distinguishes a few. My lord, the consistent finding, and I shall try and satisfy your lordship on this, that all the courts have almost uniformly held that, my lord, it is a contextual definition. Now, may I place this judgment which I had placed, my lord, a few more paragraphs, my lord, than apart from the ones I had placed yesterday. But could I humbly beseech your lordship to kindly have a look at page 2, where the arguments of the petitioner has been recorded, my lord, just for the completeness of the my argument. May I please paragraph 2? Mr. Such and such learned advocate for the petitioner submitted that this court had the jurisdiction to entertain this application and pass necessary orders. According to Mr. Such and such, as the High Court at Calcutta was the appointing court, it could exercise such power of extension under its ordinary or original civil jurisdiction. And I need to distinguish the next case. Distinguishing the decision of the Honorable Apex Court in the matter of such and such, reported in 2024 SCC Online SC 1801, Mr. Such and such submitted that the judgment should be read in the context it was delivered. The order of the Meghalaya High Court, which was upheld by the Honorable Apex Court, was distinguishable on facts. In the matter before the Meghalaya High Court, the prayer for extension of the mandate of the learned arbitrator was rejected, as the arbitrator was appointed by the parties and not by the court. In such circumstance, the Meghalaya High Court held that court would mean the principal civil court of original jurisdiction in the district and did not include the High Court. The High Court of Meghalaya did not exercise ordinary original civil jurisdiction. Thus, the definition of the term court under Section 21E of the Act should mean only the principal civil court of the district, and the said court alone had the jurisdiction to entertain the application for extension of mandate. And only a few courts, may I pause here with my lord's kind indulgence?
Yes.
But only a few high courts in the country have the ordinary original civil jurisdiction. Otherwise, it's always the appellate jurisdiction, right? And the other district courts may not have the jurisdiction. But we have the ordinary original civil. Then, paragraph 3. It was submitted that the legislative intent was to include a high court exercising ordinary original civil jurisdiction within the definition of court. According to Mr. Such and such, although the said act had undergone many amendments, no such amendment has been incorporated in Section 21E to exclude the jurisdiction of High Court. The Meghalaya High Court, on the other hand, could never be treated as the court exercising original jurisdiction. The term court used in Section 29A4 should be so interpreted by applying the expression unless the context otherwise requires. The term court should be given a definite meaning in accordance with the surrounding context or circumstances. In this case, the literal meaning of the expression court would be contrary to the intention of the legislature. Mr. Such and such submitted that the Meghalaya High Court gave a contextual interpretation of the term court, keeping the object of the statute intact, so that the interpretation did not result in defeating the purpose for which Section 29A was inserted by an amendment. As the arbitrator in the case before the Meghalaya High Court was not appointed by the High Court, as per the ratio in such and such, the principal civil court in the said case would be the commercial court at East Kashi Hills, Shillong. The said commercial court would have jurisdiction to entertain the application under Section 29A for the extension of the mandate. No anomalous situation would arise therefrom, inasmuch as the arbitrator was not appointed by High Court and the High Court did not exercise ordinary original civil jurisdiction. In the said case, the textual and contextual interpretation of the expression court were in sync. According to Mr. Such and such, on the above findings arrived at by the Meghalaya High Court, the decision was rendered by the Honorable Apex Court on 13 May 2024 in Chief Engineering. The issue before the Honorable Apex Court was the validity of the decision of the Meghalaya High Court in holding that the said High Court was not the principal civil court having original jurisdiction. Court as defined under Section 21E of the said Act would have the jurisdiction to extend the mandate under Section 29A4 of the Act. It was also held that the situation would be different had the arbitrator been appointed by the Meghalaya High Court, as in such a case, a contextual interpretation of the term court would have to be made. It was further observed by the Meghalaya High Court that an anomalous situation would arise if the High Court appointed an arbitrator, but the application for extension was filed before the principal civil court in the district, and a prayer was made for substitution of the arbitrator. In such a situation, the expression court would require a contextual interpretation. Otherwise, an arbitrator appointed by the High Court would stand removed by the principal civil court, being the subordinate court. This would militate against the provisions of Section 11(6) of the Act. But I'm not troubling your lordship with the other paragraphs because some of these are repetitions of the submissions on this very same point. Now, if my lord is pleased to have a look at.
So the only reason why the order was upheld as far as Meghalaya High Court was concerned, that they didn't have the original jurisdiction, as well as it was not an appointment done by the High Court. These were the only.
It was a party appointed arbitrator. So, and coupled with the fact that there is no ordinary origin. So these are the two facets which had led to the Meghalaya High Court order and the Supreme Court order. So, your lordship knows better than all of us that a judgment is an authority for the proposition it decides. But the ratio has to be looked into the facts, what has come. So, in these facts, that was the judgment of the Honorable Supreme Court, which said no, 29A, you should go before the district court.
Right, so
but that cannot be.
What are the facts over here? Your
in the instant case, yes. But in the instant case, Malad will kindly have a look at page 67. This I had placed yesterday also. This is the order appointing the arbitrator under Section 11. Kindly takes a look at page 67. 9 December 2019 order.
Yes.
Well, we'll find and the opening sentence of this judgment, my lord, there is an application under Section 11(6).
Yes.
Now, my lord, as I had placed, my lord, this learned arbitrator had passed away, unfortunately, in 2022. So, my lord, a Section 15 application was filed.
Yes.
My lord, kindly turns to my lord, page 77, and my lord will find Section 15. This is the Section 15 application. That is once again the opening sentence of the judgment. My lord, there is an application under Section 15 of the 1996 Act.
Yes.
But here, my lord, as 15 really falls back to 11, and my lord, this was the arbitrator, because of his death, my lord, could not. So, my lord, the substituted arbitrator was appointed by this very order, my lord, at page 78.
Yes.
Now, the parties had extended by consent for 6 months. After that, my lord,
Where is that order? That's in the second volume, right?
my lord, by consent.
I think it's page 201.
201 is, my lord, the last minutes. My lord, that is where they both the parties submit that they would file application under 29A before the High Court.
Where is the consent where the first extension was granted?
Kindly gives me a moment, my lord. I have annexed the minutes at page 94. My lord, will kindly bear with me, my lord.
Is it 184? Just check.
I'm sorry. In 184, there is no extension which is recorded. I'll just indicate to it. Yes, kindly comes to my lord, page 171. I'm really sorry, my lord. I should have been ready with this. Page 171.
Yes.
This is the 24th sitting, my lord. Held on 30th of March 2025. My lord will kindly turn to page 172. Now, this records the mutual consent and the expiry of the mandate on the 2nd August 2025. The stage of the arbitration is that the witness action of the claimant is over and the witness action of the respondent is to commence. The affidavit of evidence has been filed, but the witness action is to commence. Now, several sittings have been held within the jurisdiction also. And the arbitration clause refers to the seat of arbitration, the venue of arbitration to be in Kolkata. Yes. That I had placed from the clause set out in my notice at page 7, which starts from page 71 at 73. The relevant clause has been set out in that notice. I am carrying the statement of claim for in case your lordship requires the contract. But we did not annex these because we did not foresee any opposition coming after the submission on the last sitting, that there would be any opposition on the question of territorial jurisdiction. So we did not annex any of these. We thought it was a mere formality, but unfortunately that is not the case. Now, this judgment of this of our High Court, but there are similar views taken by courts throughout the country. I have judgments of of Goa, Delhi, where same views, Bombay, where same views have been taken. That contextual definition would mean that High Court, if passed an order under Section 11, would be the court for 29A because of the other provisions in 29A, which is 29A6 to be precise, which gives the power of the 29A court to also substitute the arbitrator. So this is where really the distinction has been drawn, that if that power of substituting is included within the 29A, and the judge, and I shall place 2 or 3 more, where the courts have held 29A is a complete code in itself, because that gives the power to put strictures, to deduct fees, to substitute, so on and so forth. So if a High Court has passed an order, then it would be judicial impropriety, if I may use this term, for any other judiciary in subordinate judiciary to tinkle with that order. But similarly, in case of an international arbitration, it's the Supreme Court who appoints the arbitrator under Section 11. But for other proceedings under the provision, it's the High Court under Section 2(1)(e). Then also the courts have held that for an international arbitration, if there is an extension, then one has to file 29A before the Supreme Court. The court appointing the arbitrator would be the court under 29A. That is the consistent view. Only aberration is the Supreme Court judgment, which I, in my humble way, taking aid of this distinction already, I'm trying to distinguish that there was no principal civil court. For your lordship's kind consideration, may I just formally place the two or three other decisions to show that this has been the consistent view of all courts throughout the country. Next step. This is the judgment of the High Court of Goa. Echoing the identical view, then I'm sorry. Which paragraph?
Para 28.
Yes, my lord. 28 discusses the other provisions of 29A. Going on to paragraph 29 and my lord, paragraph 30. Which one? Why sports? Yeah. Was this considered?
Para 29, last line.
I'm grateful. Man. And then again, going on to my lord, paragraph 30, where my lord, it says it's a discretionary power under 29A4. Then it would be open to substitute. So that power paragraph 31 also, if my lord is pleased to take a look at.
Yes.
Then my lord, finally, paragraph 34 at my lord, page 39, the penultimate page of the judgment. Paragraph 34, the final view after discussing all the above issues, my lord. The later judgments. This is the.
Yes.
Okay. Yes, my lord, one other judgment. This is pre the Supreme Court judgment. The one which I cited is after that. My lord, this pre Supreme Court judgment, again widely followed throughout. But here also the Honorable Delhi High Court, but I'll give your lordship the concerned paragraphs, my lord. The submissions are recorded from paragraph 8. Now the findings, my lord, will find from paragraph 25 onwards.
Yes. 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 And my lord, one other judgment which has been followed by our single bench judgment by Honorable Justice Shorkat. This is again pre the Supreme Court, but this also discusses the identical issue, a coordinate bench judgment of this Honorable Court, referred to in both Delhi as well as Justice Shorkat's judgment. My lord. This is Amit Kumar Gupta. My lord, kindly cease from my lord, paragraph 17 onwards, where the contextual definition of court has been my lord, considered. Paragraph 17 and 18. My lord. Yeah. Yes. My lord, uh, just just to preempt the possible arguments of my learned senior friend appearing for the respondent, my lord, they might take the point that there is no jurisdiction clause or forum selection clause, but there is a clause in the arbitration clause which says the venue of the arbitration would be in Kolkata. So that may not attract the jurisdiction, and Kolkata is wide enough to include their office or any other courts. They have already subjected themselves to the arbitration proceedings.
Yes. And sittings have been held within jurisdiction as well. So it is not that that venue is there and parties have chosen to waive that or something. There cannot be the case. That is one. And the other is, well, because the Section 11 was passed and the 15 read with Section 11 order was again passed, well, also this court would have the jurisdiction, and well, no other court would have. Those are my submissions. I'm sorry, just one more. This is a 2025 judgment of the Honorable Division Bench of the Hyderabad High Court, but which we have found dealing with the same issues. Just to show that courts throughout the country, paragraph 14 onwards. Going on to paragraph 16.
Yes.
Paragraph 21 of this judgment considers the Bombay High Court Division Bench of the Goa bench.
I saw that.
And also at paragraph 22, it says that the commercial court erroneously permitted that application. Paragraph 22, we thus have no doubt that the extension of the arbitrator's mandate in the present case was erroneously permitted by the commercial court. This was in civil revisional jurisdiction. Those are my submissions. I'm grateful.
Kindly take section 11.6.
First of all, you tell me that you had already consented,
Yes, my lord.
and the order, the last order which has been passed is also with your consent to the
Yes, my
extent that you will be. Then why this opposition?
But we are consenting to extension of the mandate.
Yes.
If they go to the appropriate forum,
This is the
on
appropriate
day one,
forum?
we will say we are consenting.
Where is the appropriate forum according to
My
you?
lord, according to me, it is the commercial court at Rajarhat. And this is well settled by several decisions of the coordinate bench.
Okay.
This is my submission. We are not opposing the extension on merit. We are not opposing the arbitration. We have participated in the arbitration.
Yes.
So, my lord, because our fear is today, if this honorable court exercises jurisdiction, then under section 42, all future applications, section 34, everything will have
If
come
you
here, which
see
has a
the-
policy issue.
The judgment
Yes, ma'am.
of Justice Basak that deals with section 42. And it actually says that the court, which is the appointing authority under 11.6, will be the court which will be deciding the extension under 29.
But the Honorable Supreme Court specific finding was that court in section 29A will mean the 2-1E court. That is the difficulty. And I'll come to that judgment
So
and
you are
other
saying that it can only be the commercial court
at Rajarhat.
at Rajarhat.
Yes.
Argue.
My lord, kindly takes 11.6, under which the Honorable Arbitrator was appointed. Where under an appointment procedure agreed upon by the parties, party fails to act as required under that procedure, or the parties or the two appointed arbitrators fail to reach an agreement expected of them under that procedure, or a person, including an institution, fails to perform any function entrusted to him or it under that procedure, the appointment shall be made on an application of the party by the arbitral institution designated by the Supreme Court in case of international commercial arbitration, or by the High Court in case of arbitrations other than international commercial arbitration, as the case may be. So, my lord, here it is the Supreme Court in case of international commercial arbitration or High Court. So, whether or not a High Court has original jurisdiction, whether or not the cause of action arises within that original jurisdiction, it may be in any district of West Bengal. Ultimately, the appointing authority will always be the High Court. But now, if we see, my lord, section 29A, subsection 4, the power to extend the mandate. If the award is not made within the period specified in subsection 1 or the extended period specified under subsection 3, the mandate of the arbitrator shall be terminated unless the court has either prior to or after the expiry of the period so specified extended the period. So here it is not the High Court. It says court with capital letter, and court is, my lord, defined in section 2(1)(e). My lord, I am coming to section 2(1)(e). Court means in the case of an arbitration other than international commercial arbitration, the principal civil court of original jurisdiction in a district, and includes the High Court in exercise of its ordinary original civil jurisdiction, having jurisdiction to decide the questions forming the subject matter of the arbitration if the same had been the subject matter of a suit. but does not include any civil court of a grade inferior to the principal civil court or any court of small causes. So, my lord, High Court can be a 2-1 court, but there are two conditions which have to be satisfied. My learned friend has stressed on only one. First is that High Court must have original jurisdiction, certainly. But the second part is that had the arbitration been a suit, in the ordinary original jurisdiction, the High Court must have had some jurisdiction. So, my lord, so general.
What is the argument? The other argument?
My lord, there are two conditions which has to be satisfied.
To my understanding, those two conditions are one, the appointment of the arbitrator under 11.6, and the second is the court
My lord,
having
then
the
kindly consider this, that there is an arbitration in Asansol. Arbitrator will be appointed under section 11.6 because only High Court has that power. But everything else has happened in Asansol or Murshidabad. So, my lord, in every arbitration where 11.6 has been done, but everywhere the section 34, the section 9, everything will fall in the High Court. My lord, in the High Court's jurisdiction, the ordinary original jurisdiction in Calcutta is restricted to only 10 kilometers radius, which is, my lord, extending from Strand Road to the Lower Circular Road, my lord, which was earlier called Lower, now it's called Acharya Jagdish Chandra Bose Road. Now, the city of Calcutta, my lord, comprises of this part, which is a small part, and also comprises of parts which are falling within the district of North 24 Parganas and South 24 Parganas. So, my lord, the commercial court at Rajarhat is also exercising jurisdiction over large parts of Calcutta, and the commercial court at Alipur is also exercising jurisdiction over large parts of Calcutta. So, just by selecting venue to be Kolkata, my lord, it cannot be said that the parties have chosen the jurisdiction of this Honorable High Court, and this is, my lord, already decided in several judgments of coordinate benches. Now, the first judgment, but where, my lord, it is again, my lord, the same party, Bharat Heavy Electricals Limited, same clause. This was considered, my lord. Judgment. Sorry, I'll come to that judgment, my lord. That is the later judgment. Sorry. Sunil High Tech. This is in 2017. Now, the second page, where the forum selection clause is given, my lord, it was Kolkata. And my lord, our office is in Salt Lake, Kolkata, which comes under the jurisdiction of Rajarhat Commercial Court, not the original jurisdiction of this High Court. The Honorable High Court held the forum selection clause appears to be flawed and in any event vague. The Calcutta High Court has not been named in the forum selection clause as it refers to civil court having original civil jurisdiction. There are several civil courts within the metropolitan area going by the name of Kolkata, which exercise original civil jurisdiction. For a forum selection clause to be effective, the exclusivity of the identified court must be spelled out in the clause itself. Again, it is elementary that a court which does not have the jurisdiction to entertain a dispute cannot be conferred jurisdiction solely by the agreement of the parties. It is only such a court that can be identified as the exclusive court that would otherwise have authority to receive a suit covering the disputes between the parties. Since there is no averment in the petition indicating that this court has authority to receive this action, and it is evident that the respondent does not carry on business or have any office within the territorial limits of this court, the petition under Section 9 of the Arbitration and Conciliation Act 1996 appears to be without basis and carried to an inappropriate forum. So, my lord, same party, its office was in Salt Lake, the jurisdiction clause said Kolkata, and the court held that Kolkata here must mean the Rajarhat Commercial Court because it's that part of it.
Entirely in a different context.
Section 9, my lord. In Section 9. Now, my lord, coming to whether 29A court is 2-1 or not. That is the, my lord, main issue. This, my lord, judgment has been followed in two other judgments with the same party. But one is the judgment of Honorable Justice Shivkant Prasad, reported in 2020, SCC Online, Calcutta, 996.
Yes.
Yes, ma'am. Kindly, my lord, come to paragraph 19 of this judgment. Mr. Rohit Das, learned counsel for the respondent, submitted that the petitioner has suppressed the true facts. Arbitration clause being 2.21.3 as contained in the said tender dated June 8, 2017 clearly states that the seat of arbitration shall be Kolkata, the place from where the contract is issued. Furthermore, the exclusive jurisdiction clause being clause 2.2 contained in the aforesaid tender states that the contract shall be governed by the law for the time being in force in the Republic of India, subject to clause 2.21.1 of this contract. The civil court having civil jurisdiction at Delhi for PSER, at Kolkata for PSER, at Nagpur for PSER, and at Chennai for PSER is in regard to all matters in respect of this contract. It is further submitted that the respondent has its power sector Eastern Region office situated in DJ 9/1, Salt Lake City, Kolkata.
Why are you showing these judgments which have
These judgments have all held that just
these
because
are
venue
no
is Kolkata
relevance.
in my
We are
contract.
talking about section 29, sir.
Yes, my lord.
So
Now
please show
let
me.
me come to, my lord, the Supreme Court judgment on 29A. Several courts had held that it will
This
take
has no
the
relevance in your.
but only to show that the original jurisdiction does not come. That is why I am placing this one, because he has relied on that one thing in the contract, venue in Kolkata. Now, my lord, he has said we have
Forget
participated.
about the original jurisdiction. The fact that the Calcutta High Court has appointed the arbitrator, they have power under 29A to extend the time.
Yes, my lord. Let me come to that, my lord. First judgment I am relying on is the Supreme Court judgment, which has been distinguished. Supreme Court. This is reported in 2024 SCC Online, SC 1801. But 29A is laid down in para 1, kindly comes to para 2. The power under subsection 4 of section 29A of the Arbitration Act vests in the court as defined in section 21E of the Arbitration Act. Well, very clear finding. It vests in the court, which is the court under section 21E. It is the principal civil court of original jurisdiction in a district which includes a high court, provided the high court has ordinary original civil jurisdiction. This is a case where, my lord, the high court does not have ordinary original civil jurisdiction on the dispute. In this case, the high court does not have ordinary original civil jurisdiction. Power under subsection 6 of section 29A is only a consequential power vesting in the court which is empowered to extend the time. If the court finds that the cause of delay is one or all of the arbitrators while extending the time, the court has power to replace and substitute the arbitrators. The said power has to be exercised by the court which is empowered to extend the time as provided in subsection 4 of section 29A of the Arbitration Act. So Supreme Court didn't find any difficulty in the district court exercising this consequential power of appointing an arbitrator in substitution. Now, my lord, this has been distinguished in the judgment relied upon by my learned friend, by Justice Shompa Sarkar. But with all due respect, my lord, Honorable Justice Shompa Sarkar has failed to consider another coordinate bench which has also taken into account this judgment and has come to the reverse conclusion. This is by Honorable Justice Thoposati Bhattacharya, my lord, this just after this judgment had come on 2nd September 2024. A preliminary objection is taken by the learned counsel for the respondents to the effect that this court does not have jurisdiction to take up the matter, since section 29A empowers a court as defined in section 21E of the Arbitration and Conciliation Act 1996 to take up applications under the said provision. It is pointed out that previously a suit was filed before the learned district judge Malda, exactly similar situation. They have filed a suit in the same dispute before the Barashat court, which has been transferred to the learned commercial court at Rajarhat. Two applications, one under section 9 and the other under section 29 of the 1996 Act, had also been filed before the District Judge Malda. It is submitted that although the learned arbitrator was appointed under Section 11 by a coordinate bench of this court, the same was under the specific powers entrusted on the High Court by Section 11. Learned counsel for the respondent cites an unreported judgment of the Supreme Court in the matter of Chief Engineer NHPWD Roads versus Messrs. BSC and CJV in support of his proposition that an application under Section 29A has to be filed before the principal court of original civil jurisdiction. Learned counsel for the respondent seeks to argue on other points as well. However, in view of the judgment proposed to be passed, such other points are not entertained. Learned counsel for the petitioner submits that previously the applications filed before the District Judge Malda were withdrawn upon imposition of costs. If at the present juncture it is held that this court does not have jurisdiction, it is submitted that it would be difficult for the petitioner to go back to the district court. This was also submitted. That apart, it is argued that provisions of Section 42 of the 1996 Act are not applicable. This is also taken into account, since the petitioner chose to withdraw the previous applications from the district court at Malda. Even without entering into the question as to whether the petitioner was justified in withdrawing the applications under Sections 9 and 29A respectively of the 1996 Act from the court of the learned district judge at Malda, at the outset it is seen that in view of the subject matter of the proposed arbitral dispute falling within the territorial jurisdiction of District Malda, this court does not have original jurisdiction to take up the matter. Although the High Court is specifically empowered under Section 11 of the 1996 Act to appoint an arbitrator, any application under Section 29A has to go before the jurisdictional court as defined in Section 21E of the 1996 Act. Since the court of the learned district judge at Malda is the said jurisdictional court, this court does not have jurisdiction to entertain the present application at all. This is not a question of applicability of Section 42 of the 1996 Act, which precludes a party from presenting an application to a different court than the first court when an application is presented under the 1996 Act, but a question of the original jurisdiction of this court, which is utterly lacking. Thus, in view of lack of jurisdiction, AP 96 of 20 is dismissed as not maintainable. So, my lord, this is the coordinate bench judgment which was there, which was not shown to his ladyship. Now, my lord knows I can, my lord, file those judgments of the Supreme Court that if there is a previous judgment of the coordinate bench which has considered the same judgment of the Supreme Court and has come to a conclusion, either, my lord, it has to be followed, or if there is a difference of opinion, it has to be referred to a larger bench. Otherwise, that becomes per incunum. So, with all due respect, the judgment of Honorable Justice Shampa Sarkar has not considered this aspect of the matter, that a previous coordinate bench has already held this aspect. These are my submissions.
Just two sentences in reply dealing with the judgment of Justice Bhattacharya, which my
judgment by the Supreme Court on the coordinate bench. And my lord, this judgment of Justice Bhattacharya also, my lord, Section 11 appointment by this High Court. But I'm just placing two judgments on the requirement to follow the previous judgment of a coordinate bench. Kindly comes to paragraphs 13 and 14. Time and again, this court has emphatically restated the essentials and principles of precedent and stare decisis, which are a cardinal feature of the hierarchical character of all common law judicial systems. The doctrine of precedent mandates that an exposition of law must be followed and applied even by coordinate or co-equal benches, and certainly by all smaller benches and subordinate courts. That is to say that a smaller and a later bench has no freedom other than to apply the law laid down by the earlier and larger bench. That is the law which is said to hold the field. Apart from Article 141, it is a policy of the courts to stand by precedent and not to disturb a settled point. The purpose of precedents is to bestow predictability on judicial decisions, and it is beyond cavil that certainty in law is an essential ingredient of rule of law. A departure may only be made when a coordinate or co-equal bench finds the previous decision to be of doubtful logic or efficacy, and consequentially, its judicial conscience is so perturbed and aroused that it finds it impossible to follow the existing ratio. The bench must then comply with the discipline of requesting the Honorable Chief Justice to constitute a larger bench. Well, this was not done. There's a difference of another judgment, my lord. This is a 5 judgment of the Honorable Supreme Court Constitution Bench. This has also considered this aspect. Well, para 16 onwards. In state of VR versus Calcutta Court, it has been held an earlier decision may seem to be incorrect to a bench of a coordinate jurisdiction, considering the question later on the ground that a possible aspect of the matter was not considered or not raised before the court, or more aspects should have been gone into by the court deciding the matter earlier. But it would not be a reason to say that the decision was rendered per incurium and liable to be ignored. The earlier judgment may seem to be not correct, yet it will have the binding effect on the later bench of coordinate jurisdiction. The court has further ruled easy course of saying that earlier decision was rendered per incurium is not permissible, and the matter will have to be resolved only in 2 ways, either to follow the earlier decision or refer the matter to a larger bench to examine the issue in case it is felt that earlier decision is not correct on merits. In GL versus State of Haryana, the court has accepted the said principle on the basis of judgments of this court rendered in union. Several my lord judgments are cited. It may be noted that the Constitution Bench in Madras Bar Association versus Union of India has clearly stated that the prior Constitution Bench judgment in Union of India versus Madras Bar Association is a binding precedent. Be it clarified, the issues that were put to rest in the earlier Constitution Bench judgment were treated as precedents by the later Constitution Bench judgment. In this regard, we may refer to a passage from Jayashree Sahu versus Rajdevan Duve. Law will be bereft of all its utility if it should be thrown into a state of uncertainty by reason of conflicting decisions. And it is therefore desirable that in case of difference of opinion, the question should be authoritatively settled. It sometimes happens that an earlier decision given by a bench is not brought to the notice of a bench hearing the same question, and a contrary decision is given without reference to the earlier decision. The question has also been discussed as to the correct procedure to be followed when 2 such conflicting decisions are placed before a later bench. The practice in the Patna High Court appears to be that in those cases, the earlier decision is followed and not the later. In England, the practice is as noticed in the judgment in Gundavarappu Seshamma versus Kornepatti Venkata Narasimha Rao, that the decision of a court of appeal is considered as a general rule to be binding on it. There are exceptions to it, and one of them is thus stated in Halsbury's Laws of England. Court is not found to follow a decision of its own if given per incurium. A decision is given per incurium when the court has acted in ignorance of a previous decision of its own or of a court of a coordinate jurisdiction which covered the case before it, or when it has acted in ignorance of a decision of the House of Lords. In the former case, it must decide which decision to follow, and in the latter, it is bound by the decision of the House of Lords. In Katragadda Viraya versus Katra, it has been held that by the Andhra Pradesh High Court that under circumstances aforesaid, the bench is free to adopt the view which is in accordance with justice and legal principles after taking into consideration the views expressed in the 2 conflicting benches. Wide also the decision of the Nagpur High Court in DD Billimoria versus Central Bank of India. The better course would be for the bench hearing the case to refer the matter to a full bench in view of the conflicting authorities without taking upon itself to decide whether it should follow the one bench decision or the other. We have no doubt that when such situations arise, the bench hearing cases would refer the matter for the decision of a full court. Though the aforesaid was articulated in the context of the High Court, yet this court has been following the same as is revealed from the aforestated pronouncements, including that of the Constitution Bench. And therefore, we entirely agree with the said view because it is the precise warrant of respecting a precedent which is the fundamental norm of judicial discipline. In this context, we may fruitfully note what has been stated in Pradeep Chandra Parija versus Pramod Chandra Patnaik. In the said case, the Constitution bench was dealing with a situation where the two-judge bench, disagreeing with the three-judge bench decision, directed the matter to be placed before a larger bench of 5 judges of this court. In that scenario, the Constitution bench stated, in our view, judicial discipline and propriety demands that a bench of 2 learned judges would follow a decision of bench of 3 learned judges. But if a bench of 2 learned judges concludes that an earlier judgment of 3 learned judges is so very incorrect that in no circumstances can it be followed, the proper course for it to adopt is to refer the matter before it to a bench of 3 learned judges, setting out, as has been done there, the reasons why it could not agree with the earlier judgment. My lord, last para 21. The doctrine of binding precedents is of utmost importance in the administration of judicial system. It promotes certainty and consistency in judicial decisions. Judicial consistency promotes confidence in the system. Therefore, there is this need for consistency in the enunciation of legal principles in the decision of this court. It is in the above context, this court in Raghuveer Singh held that a pronouncement of law by a division bench of this court is binding on a division bench of the same or smaller number of judges. And my lord, so far as sittings of the arbitration are concerned, it has been held, some have been held here, some have been held in Salt Lake within the jurisdiction of Rajat Commercial Court, some have been held virtually. And my contract, my lord, entire contract was in Salt Lake. Nothing has happened here. Their office is in Delhi. My office is in Salt Lake. The contract was performed in Bokreshwar in the district. So, my lord, there is no part of the cause of action. Neither do the parties have any office, place of business, nor there is any cause of action within this Honorable Court's jurisdiction. These are my answers.
Very short reply. Kindly takes a look at the judgment which my learned friend had placed, 2017-16 Supreme Court cases. Just one sentence from this. The last one, 2017, volume 16, Supreme Court cases, 680.
Yes.
Now, kindly takes a look at paragraph 18 at page 698 of the report. Now, towards the middle of the page at Placetum D, your lordship would find paragraph 1687 of Halsbury's has been quoted. Kindly seize the first sentence. The court is not bound to follow a decision of its own if given per incuriam. So, my lord, decision which is per incuriam is not a judicial precedent at all. I humbly submit with utmost humility, my lord, that the judgment which my learned senior friend had placed of a coordinate bench of 2nd September 2024 is a per incuriam judgment. So, my lord, the later judgment of Honorable Justice Shorkat need not have followed this or, my lord, referred it because it's not a binding precedent. This judgment is per incuriam because it did not follow the other judgment which I had placed on Amit Kumar Gupta. My lord, where your lordship pointed out that section 42 was also discussed. My lord, judgment of Justice Boshak. That has not been followed. No discussion on that. And also, my lord, this is one further judgment of a coordinate bench. My lord, I'm really sorry for the printout. My lord, some line has come in the first page. Kindly pardon us, my lord, for this, my lord. Kindly pardon us, my lord, from the printout, some line has come, my lord. The next pages are all fine. But this is...
सुनिए ACO है ना ACO कब से since when are you an ACO? When do you hand over a judgment? What do you write? The number and what do you write? Do I need to tell you that? Not again. Yes.
So, my lord, the previous judgment which I had cited, my lord, 2021 SCC Online Calcutta 2174 by Justice Boshak, that was not considered. And also this judgment of Justice Bhattacharya, my lord, this is, my lord, 2024 SCC Online Calcutta 1921. But here also this issue was there, and Lordship would kindly have a look at paragraph 25 at page 5 of the report. The last sentence on that page, the respondent says that the application should be filed before the commercial court at Asansol. Council relies on section 11(6) of the Arbitration Act in the context of the definition court under section 21E, and also relies on 29A6. Only substitute, then kindly sees the findings. Paragraph 29 and 30, this objection is rejected. And the application is allowed by extending the mandate. So, my lord, in my humble submission,
Yes.
in my humble submission, the judgment in the case of Nandita Mistry of Justice Shobboshachi Bhattacharya is perhaps, my lord, subject to what falls from your lordship, is per inquirium, because it did not consider two binding precedents prior to that, Justice Devanshu Boshak and Justice Moushumi Bhattacharya. So, my lord, that not being a precedent, because it's per inquirium, Justice Shorkar need not have, my lord, even considered that. So, my lord, Justice Shorkar's judgment is not per inquirium, and it is a binding.
Only one line in reply to the judgments relied on in the reply. My lord, Amit Kumar Gupta, that was, my lord, decided on 3rd February 21, and this Praxair judgment which has been given is decided on 22nd February 2024, before the Supreme Court judgment. Supreme Court, my lord, came up with its judgment that 2-1E is the court in July. Then in September 2024, Justice Bhattacharya followed the Supreme Court judgment, which it was bound to follow, and not a previous single bench, coordinate bench judgment. So, my lord, rather Justice Shampa Sarkar should have considered that the Supreme Court judgment has already been considered and that there is a judgment. It should not have diverged from that view instead without referring it to a larger bench.
What about the fact that Justice Bhattacharya's judgment, the reason why he could have come to that finding is also because they had filed in a section 29A before the subordinate court.
Yes.
So that could be a reason that he didn't entertain it.
But I would
it was
humbly
withdrawn.
submit it, because that cannot be the ground, because the section 11 court, the High Court in a section 11 has appointed an arbitrator, and that has been the consistent view throughout. So, my lord, that view in my humble submission could not have been taken because of the earlier decisions also. And the Supreme Court judgment is really, my lord, on a different fact. So, my lord, that cannot be imported, my lord, to aid the opposing respondent on this point. That is on a completely different fact. And that is also dismissal of a special leave petition. I do not know, my lord, whether that would, how much precedentiary value that would be. Because, my lord, in your lordship knows, in Kunai Ahmed and all, those are not, my lord, really a merger. So, my lord, even if a special leave petition is dismissed, the court was considering, my lord, whether a special leave should be granted to prefer an appeal. So, it is only on that limited count the Honorable Supreme Court was considering the special leave petition. But that really perhaps, subject to your lordship's kind interpretation, my lord, would perhaps not be a binding precedent also. And, my lord, your lordship has seen, my lord, this judgment in Nandita Mistry, my lord, none of the other judgments of any other court have been, my lord, considered. Also, my lord, the binding decisions of our Honorable Court.
Take down. The petitioner has filed the present application seeking under section 29A, seeking extension of time for conclusion of the arbitral proceedings and publication of the award under the provisions of the Arbitration and Conciliation Act 1996. Full stop. Learned counsel for the petitioner states that the arbitrator was appointed by this court by order dated 9th December 2019 in AP number 496 of 2019 under section 11(6) of the Arbitration and Conciliation Act 1996. Full stop. He further submits that the arbitration proceedings were continuing before the tribunal, but due to the demise of the arbitrator on 27/7/2022, the proceedings were stalled. Full stop. He further states that an application under Section 15 of the 1996 Act for substitution of the arbitrator was filed. Full stop. This court-wide order dated 13th June 2023 in AP 243 of 2023 appointed a new arbitrator. Full stop. The mandate of the arbitration proceeding expired. When did it expire?
Yes, my lord, I'll just indicate. Uh, 12th August
On 12th August 2025.
2025.
Full stop. The order of the sole arbitrator dated July 23, 2025 records that the parties have agreed to file necessary application for extension of mandate of this tribunal in terms of Section 29A of the Arbitration and Conciliation Act before the Honorable High Court, and they will take necessary steps accordingly. Full stop. In view of the said understanding, the petitioner has filed the present application seeking extension of time. Full stop. Learned counsel for the respondent opposes the said application and states that the present application is not maintainable since the High Court is not having the original jurisdiction to entertain the present application. Full stop. Learned counsel for the petitioner has relied upon the judgment of this court in the case of Amit Kumar Gupta versus Deepak Prasad, 2021 SCC Online Calcutta 2174. Best Eastern Business House Private Limited versus Mini Pradhan AP Com 296 of 2025, as well as Praxair India Private Limited versus Steel Authority of India 2024 SCC Online Calcutta 191921. Full stop. He has further relied upon decisions rendered by different high courts on the same issue, which are a decision rendered in the Telangana High Court in Civil Revision Petition number 739 of 2025, Delhi High Court decision reported as 2020 SCC Online Delhi 2501, and a judgment of the Bombay High Court at Goa in writ petition number 88 of 2024. Full stop. Learned counsel for the petitioner has advanced his argument to support the contention that the present application is maintainable in terms of the fact that the arbitrator has been appointed by this court under Section 11(6) on 9th December 2019 by a coordinate bench of this court. Full stop. He has relied upon the definition of the word court under section 21E of the Arbitration and Conciliation Act to impress his argument that the section court to impress the argument that this court has the power to entertain the present application. Full stop. The point of lack of jurisdiction for deciding the extension of the mandate in terms of the fact that this court does not have the original jurisdiction and that the commercial court at Rajarhat would be the appropriate court to decide the application is against the settled position of law since the arbitrator has been appointed under section 11.6 and 11.6 of the Arbitration and Conciliation Act 1996, and in the context of definition of court under section 21E of the said act, the jurisdiction shall be with the High Court. He further relies upon section 29A(6) of the act to argue that the court can only substitute an arbitrator, but not reappoint the same arbitrator. He relies on section 29A(6) of the act to argue that the court of competent jurisdiction will be the High Court, which has appointed the arbitrator in the present case. Full stop. He further states that this court has consistently taken the stand that the word inverted comma court used in section 29A partakes the character of the appointing authority as prescribed under section 11 of the act, and therefore can only be the court which has the power to appoint an arbitrator under section 11. Full stop. Full stop. To impress this argument, he has stated that the arbitrator in the present case has been appointed under section 11 by order dated 9th December 2019. Full stop. The other judgments relied upon by the petitioner also reiterates the same set of law. Full stop. Learned counsel for the respondent has relied upon judgment of the Honorable Supreme Court in Chief Engineer NHPW Roads versus BSC and CJV, reported as 2024 SCC Online SC 1801 to state that the power under subsection 4 of section 29A of the Arbitration Act vests in the court as defined under section 21E of the Arbitration Act, and that the principal civil court of original jurisdiction, which in this case is the court at Rajarhat, would be the competent court to entertain the present application, and it would preclude the High Court to entertain the application since the High Court does not have the ordinary original civil jurisdiction. Full stop. He has relied on the mandate of the Supreme Court judgment to advance his contention. Full stop. He further states that the coordinate bench of this court in Nandita Mistry versus Sujoy Saha and another, while order dated 2nd September 2024 in AP 96 of 2024, has relied upon the judgment of the Honorable Supreme Court and had passed an order whereby the territorial jurisdiction to entertain the application under Section 29A was given to the District Court of Malda, having the original jurisdiction, and that the High Court was precluded from entertaining the said application. Full stop. He has further relied upon the fact that the coordinate bench of this court has already decided the issue based on the Supreme Court mandate, and that the other judgments passed by the coordinate bench should have relied upon the judgment of Nandita Mistry, AP 96 of 2024. Full stop. Anything else? This court has heard the arguments advanced by the counsel for the parties. The Act, under Section 2(1)(e) of the Act, it is clearly mentioned that the court of the original clearly mentioned that the court, the definition of court means the principal court, civil court of original jurisdiction in a district, and includes the High Court in exercise of its ordinary original jurisdiction, having jurisdiction to decide the question forming the subject matter of the arbitration, if the same has been subject matter of a suit, but does not include any civil court of a grade inferior to such principal civil court or any court of small causes. Full stop. In the present case, since the appointment has been made under Section 11(6) of the Arbitration and Conciliation Act, this cannot be the intention of the legislature to create a disharmony by giving the power of deciding an application under Section 29A to a court inferior to the High Court. The dicta of the cases which have been relied upon by the petitioner to substantiate and support his argument that the High Court has the power to entertain application under Section 29A is the correct proposition of law, and the judgment of this coordinate bench in Best Eastern Business House Private Limited versus Meena Pradhan, AP Com 296 of 2025, has dealt with the said proposition and has also taken into account the judgment passed by the Honorable Apex Court, and has come to the conclusion that the High Court will have the power to decide Section 29A application. Full stop. This court is in agreement with the said proposition of law, and in view of the said finding, the application under Section 29A is allowed. The mandate of the tribunal is extended for a period of how much time you want? 6 months.
Some more time, because our evidence will be there, then arguments.
It's extremely voluminous. The statement of claim is 15 volumes. Extremely
How much time?
voluminous. But could it be a year, my lord? Subject to what for?
Is extended further for a period of 1 year, since both the parties state that the evidence is voluminous and will take considerable amount of time to conclude, full stop. In view of the peculiar facts and circumstances of the case, this court extends the mandate for a year. 8 months would be fine.
I bow down, whatever.
For a period of 8 months. For a period of 8 months to conclude the proceedings. Full stop. The application is allowed.
Great.
I'll deal in detail with the judgments.
I'm great.
Great.
ये दे देना, इसको डिटेल से डील करना पड़ेगा. आज फिर से एक है. ठीक. Yes.
I'm appearing for the respondent, your lordship. This is an application for extension of the mandate of the learned arbitrator.
The application for extension of the mandate of the learned arbitrator. I believe, lordship, both the parties have consent for extension, your lordship.
The petitioner has preferred the present application. The petitioner has preferred the present application under section 29A of the Arbitration and Conciliation Act 1996, seeking extension of time for conclusion of the arbitral proceedings and publication of the arbitral award. Full stop. Learned counsel for the petitioner submits that this court, by order dated 22/11/2022, passed in AP number 863 of 2022, had appointed a sole arbitrator to adjudicate the dispute between the parties. Full stop. The mandate of the learned arbitral tribunal expired on 14/4/2020.
15th October, your lordship.
October 2025. Full stop. It is stated that the parties, by mutual consent, had extended. No, first extension.
First extension was done. It expired on 15th October.
First, जहाँ वो लिख रहे हैं ना, that it expired on 14/4/2025. The parties by mutual consent had extended the time till 15/10/2025. Full stop. The evidence of both the parties have been concluded, and the matter is presently fixed for final argument.
Yes.
Final argument. Full stop. In these circumstances, the petitioner is. In these circumstances, the petitioner has approached this court seeking extension of the mandate of the arbitral tribunal further for a period of
6 months.
6 months. Full stop. Learned counsel appearing for the respondent submits that she has no objection to the prayer made by the petitioner. Full stop. Considering the submission of both the sides, this court is inclined to extend the mandate of the tribunal further for a period of 6 months. Accordingly, further for a period of 6 months. Full stop. With the aforesaid direction, the present application is disposed of. Order as to cost.
But may I have your lordship's leave, my lord, 6 months from the date of this order or from the date of expiry?
6 months from
15th of October 2025.
If it could be from the
15th
date of this order, because after 15th of October, no sittings have
6
been
months
held.
from the date of this order.
My lord, grateful.
It's just final argument. How much time
Yes,
do you
no,
need?
my lord, for the award being
Even if it is
pronounced.
from 15th October.
For award, your lordship.
We are sitting on, is extended from 15th of October for 6 months.
Very ठीक.
Yes, Suniye. Is extended from 15th of October 2025 for a period of 6 months. Finish it off. You basically need not even 6 months.
But may I indicate one thing? My lord, a third party has sought to intervene in the proceedings. And my
I'm
lord,
not concerned with the third party.
my lord, that also has to be decided by the
I'm not concerned. Whatever the arbitrator has to decide, there's a limited jurisdiction as far as this court.
Yes, I understand. Great.
Lordship, in this matter, Lordship, Shani Roy Chaudhary is appearing for the petitioner.
For the respondent, this is a section 34 application.
Lordship,
Affidavits may be called for because they have already.
Lordship, my senior counsel is out of town, Lordship. She will come on 15th. Kindly
Coming
adjourn this matter after 15th, your Lordship.
Why is it listed today? You listed it.
It's a 34 application under section 36(2), my lord. I think he had gone out of the list for some reason. This
No, but
should
that's
have been
okay.
there earlier.
Monthly list of November 2025. ऐसे तो सारे मैटर हैं, सब लगा दो. ये क्यों लगा? What is so special about this? Huh? Learned counsel for the petitioner states that proxy counsel for the petitioner states that the main arguing counsel is unavailable and prays for a short adjournment. Let this matter be listed on. When do you want?
17th or 18th. As your Lordship concerned. After 15th.
There's nothing there, my lord. We will file our affidavits. No, it's coming after a long time, my lord.
18th.
18th.
18th. You want to file your affidavit? I'll pass. I'll give it.
My lord, there's nothing else.
All right. Learned counsel.
Because they have already deposited the money.
Learned counsel for the respondent seeks and is granted
4 weeks, my lord, because it's a voluminous
4 weeks time to file his
affidavit in opposition.
Let this matter be listed after 6 weeks.
The only thing there is a prayer for condonation of delay. We'll deal with that in our affidavit.
After 6 weeks.
Great.
My lord, this is my application under section 34 of the Arbitration Act, my lord, seeking setting aside of an arbitral award. My lord, perhaps my learned friend would like to file an opposition.
All papers are not there.
My lord, all papers are there
have
in the
no-
arbitration.
No, it's not there. It's not there. There are 12 volumes, my lord, of papers. Those are not there. It's only, my lord.
My lord, my learned friend is not carrying the entire brief. I have the entire
I have it. I've checked up.
brief now.
We'll file affidavits. Whatever is not there, I'll enclose it. Where is the difficulty? Era RO paper hai.
The petition, the presented petition. The petition has filed the present petition under section 34 of the Arbitration and Conciliation Act 1996, challenging the award dated.
Award dated, my lord, 20th June
20th
2025.
June 2025, passed by the learned sole arbitrator. Full stop. Learned counsel for the senior counsel for the respondent, Mr.
Affidavits, lordship.
Mr.
Devnath Ghosh. Mr. Ghosh.
Mr. Devnath Ghosh seeks and is granted
Lord, 3 weeks time, lordship.
4 weeks.
4 weeks, lordship.
4 weeks time to file affidavit in opposition. Is there a system of filing exception also?
No.
No.
It's a records, whatever.
Records are there. I mean,
records are
in
there.
arbitration, why do you file? Why is it even required?
It's not even required, my lord.
Not
If
required.
anything is left, I'll enclose in my
My lord,
affidavit.
9
That's
volumes
all.
are there, nothing is. I
9
filed
volumes.
it personally.
Very well. Lordship,
But
can
why
read
do you
it.
even file affidavits?
Not necessary, whether if lordship doesn't want, well, I'll not then let him press his application. Whether I have to defend a 34.
List on. When do you want? After 4 weeks time, no? We are given after 6 weeks.
Wait.
The petitioner has filed the presented petition under section 34 of the Arbitration and Conciliation Act 1999. Petition, my name here. The petitioner has filed the present petition under section 48 petition.
My lord,
I'll
time
file
to
a
file reply 2 weeks.
Well, he will.
Side में कहाँ से red petition?
I'll file an execution. There is no stay. Then he will come with a stay. Obviously, thereafter.
When he files an execution, my stay is ready, my lord.
Mr. Ghosh, this is very interesting. You have separate proceedings.
Yes. In here we have separate.
You don't, I mean, I've never seen something like this. You know, you have 34, then you have the stay application,
You have the
36
stay
too. Here, the whole
Separately.
proceeding is separate. And even the file doesn't come when you are hearing 36 unless until you specifically call for it.
Unless it's tagged, my lord.
You have to give a
Unless
requisition
unless
for
it's tagged.
tagging the 34 and the
it's tagged.
36 together.
Different style.
My lord has kept it after 6 weeks.
In the appellate side, the file comes out of.
It comes out right.
Great.
But I appear for the petition award holder, man.
I appear for judgment debtor.
But there was a order of attachment of the bank accounts.
Yes.
And a direction was given, my lord, to file the affidavit of assets, and today was fixed for examination of the judgment debtor, my lord.
We have filed the affidavit of assets, my lord. It's part of the records, my lord. Union of India, we have filed it, my lord.
We don't, not on record. Hey, dekho.
File করা আছে তো?
সার্ভিস করেছে তোমার
affidavit of assets দিয়েছে তো?
দিয়েছে ওখানে খুঁজে পাচ্ছে না তোমার
না না ফাইল করেছে। Affirmed on 19th of March 2025 itself.
It's not here on record. Ensure it's on the record. Eh? Affidavit of asset is here.
Yes, my lord, only one thing, my lord, today the matter was fixed, my lord, for examination of the judgment debtor, my lord. I don't know, my lord, whether he's present
He's
or not.
present. The only thing is that, my lord, the person who has affirmed this affidavit of assets,
Yes.
he has been now transferred to a different department. So, my lord, the person now who is there in this post, he has come.
But he can't do that, right? You have to call the other guy. You have to call the other person who has sworn this affidavit, only he
But
can
he is
make
now no longer, my lord, in the same post. My lord,
Yeah.
all that I can do is that I can file a fresh affidavit who has been now promoted to this post. I can do that because the affidavit would
But
remain
only-
the same.
Only one thing, my
Only
lord.
the affirmation part would
But there was an order of attachment of the bank accounts.
Yes.
But if a lordship kindly takes up the affidavit of assets, my lord, the details of the bank accounts are there. My lord, the cash in bank is shown as nil. But I really don't know what has been attached. But I would be pressing, my lord, prayer F of my tabular statement, my lord, today in that event, my lord. Because the amount is over 4.5 crores. It has to be secured, my lord.
But these are, my lord,
Kindly see spread
departmental
F, my lord.
accounts, which the amount comes for only
My
for
lord,
salaries.
3 bank accounts, my lord. The cash in bank is shown as nil.
Statement বার করে দিতে বলো। আছে?
But kindly consider prayer F of my tabular statement, my lord. It's an award of 4.5 crores.
We can enclose the statement also, my lord, because this is a government department. So there is nothing to hide as such. We will, my lord, enclose the statements in the new affidavit, even if your lordship wants, my lord.
Yes, tell me. They'll file a
But
fresh.
some sort of a protection, my lord, will
What
kindly
protection?
consider this. But it's a 4.5 crores award, my lord.
What
There was an order
protection?
attachment, my lord.
There is already an order of attachment of the
Attachment
account.
is there?
It is
But
there.
the cash is shown as nil in the bank accounts.
Whatever it is. Respondent says Union of India.
Yes.
Which department of Union of India?
But this
CPWD, my
this is CPWC.
How come CPWD has zero money in their account?
Yes, my lord.
How come CPWD has zero money in their account?
My lord, the money comes in as salaries, it goes out, my lord. That is the only issue, my lord. The money is not kept in the account, my lord, as such in this department. But we'll file the, my lord, statement, my lord. That is, my lord, there is nothing to hide as such.
What was the order which was passed on 29th?
But order is
an order of attachment of the bank accounts, which has been passed
but
on
order
the
of
trust.
18th of August, my lord. There was an order of attachment of the
bank accounts.
account for a sum of rupees 5 crores, my lord.
That's, my lord, the awarded sum. And, my lord, he was asked to be present for, my lord,
Examination.
examination, which is there. But, my lord, Ideally, my lord, he should, the person who would go into the box should file an affidavit.
Oh, that has to be there.
Yes. That we can do, my lord.
But some sort of a protection if it commences to your lordship, my lord, today.
No, but has he deposited the awarded sum?
No, my lord, the order.
He had filed a section 36(2). There was an order passed, my lord, by the commercial court at Rajarhat.
Right.
My lord, they could not comply because the government did not have that amount of money, my lord, to put in and secure for a stay. So that order was vacated. And then this execution, in this execution proceeding, my lord, her ladyship had passed the order, my lord, injuncting and restraining us from operating the accounts. And he was asked to be present today for, my lord, examination. I am humbly praying, my lord, that I can file a fresh affidavit and thereupon he can be examined, my lord.
Any other account which is there?
But these are the only 3 accounts which he has also disclosed in the affidavit of assets, my lord. But as things stand up now today, my lord, today I am not secured, my lord, because I don't know, as per his affidavit, my lord, there is no cash lying in the bank accounts. But some sort of a protection, my lord.
What protection can I give you?
But kindly then considers at least Fred D, my lord. Let him be injuncted from disposing of his assets.
The government department, they don't dispose of assets like that to run away from.
But my lord,
PWD.
Three bank accounts, my lord, the cash shown is nil.
এই তিনটে অ্যাকাউন্টের স্টেটমেন্টে কোনো টাকা নেই। ও ওই যে এটা এই অ্যাকাউন্ট অন্যরাও ইয়ে করে এই যে KCD 3 আচ্ছা। Now, there is also one issue, my lord, which my lord, he rightly explained. If your lordship sees, my lord, the cause title, it is CPWD KCD 3. Now, my lord, in these accounts, there are other amounts also of the various other departments of the Union of India. This is, my lord, a blanket order which has stopped, my lord, all these amounts also. So, my lord, now when we disclose that, we'll also disclose, my lord, what are the other departments and what amount they are having, because
I've only given these account details.
Yes, correct, my lord. It has been.
Today you can't say.
No, I am not saying, my lord, but this is, my lord, I'll attach the statement and I will also, my lord, my lord, show them, my lord, what are the other departments, what they have, because there is no award against them.
See, you have already filed your asset.
Of course, my lord.
You can't.
I will attach the statement. No, I am not one. Union of India cannot run away, my lord. We are not going to run away. But of course, my lord, there cannot be any injunction against, my lord, the other departments because there is no award against them. So that also, my lord, I'll clarify, my lord.
This is your. You have filed the
affidavit. Correct.
Affidavit.
Correct, my lord.
We have not asked you.
No, not at all, my lord. Not at all.
Your self-declaration.
Correct, my lord. So we will, my lord, as I am saying, my lord, we'll file a fresh, my lord, let this injunction be there. We'll file a fresh affidavit, my lord, which would be affirmed by the gentleman who will go in the box.
I leave it to your lordship, my lord.
Learned counsel for the respondent states that the affidavit of assets filed by, who was the gentleman who had filed it? By him, Narayan Bharati, who was working as the executive engineer CPWD office at who was working as the executive engineer CPWD has been transferred, and Mr.
Prantik
Roy and
Prantik
Mr. Prantik Roy has assumed the role of executive engineer CPWD, dealing with the present petition. Full stop. Since the petitioner wants to examine the respondent, the concerned officer of the respondent, Union of India, it is learned counsel for the respondent states that he shall be permitted to file an affidavit by Mr. So and so, Prantik so and so,
Roy,
so that the petitioner is able to examine him. Full stop. But you can always call the gentleman. Where is he? He's not out of the world.
No, but he is, my lord, no longer, my lord, in this department at all.
No, he's been transferred. No, but see, that doesn't mean, sir, let me be very candid. That doesn't mean the person can't testify. He can always come and stand on the
My lord, but
box and he can testify.
now, my lord,
The person who has dealt with the issue should testify for it.
my lord,
Suppose a sanction has been given by X person. Will that person come to testify, or somebody else will come to?
no, my lord, correct, my lord. What is falling from my lord is correct, but my lord, this person also who has affirmed, he was not there when the transactions took place. So whoever is there in the
So
chair, my
tomorrow
lord,
he-
affirms it.
So tomorrow he gets transferred, then another affidavit.
But that is why I'm saying a fortnight's time he won't be transferred.
See, this
So that he can come before in the
is a
box.
very, I
Because,
don't
my
agree
lord,
with
the
this.
person
This
in
doesn't
the
appeal to me at all.
because, my lord, the person who is
Where
there
is he transferred? Where is he?
transferred to the headquarters, my lord.
Where is he?
His posting is at Kolkata.
Call
He
him.
can come, my lord, any day, my lord.
Call him. You call him next time.
Very well, my lord.
Strike the order. Learned counsel for the respondent assures that Mr. So and so, who has filed his affidavit, will remain present on the next date to enable the petitioner to examine him. Full stop. Give a date. When? Next week?
But any day, subject to
After 2 weeks.
Grateful.
He's in Calcutta.
No,
At least you
he's
should.
in Calcutta. CPWD is
A
the
person-
department in Calcutta,
You
my
are a
lord.
senior counsel. You should take instruction from these guys. If you let them go like this,
I am not at all. That is why he is present in court to be examined.
but
my
if you let people go like this, where they are posted in Calcutta, maybe in a different department, they should come and testify.
My lord, there is no issue in coming in testifying. Only that, my lord, he is
I
no
can
longer having
understand.
the jury. My lord, in that case, the
He
authority in that chair.
He will have the authority. See, the department will always give him. He is the person who has signed the affidavit.
Yes.
It is always the case. Who knows better than you? Why are we arguing about
My
it?
lord, I will then keep this gentleman also, my lord,
Keep
so that,
them.
my lord, because
Assistance can be
there is
provided. He
an,
might be in
my lord,
custody
there
of the
is some
document.
administrative issue. I'll keep him also, my lord. Grateful.
Grateful.
कहाँ से शुरू होता है?
23. Econ 675 of 2020.
Who's for the petitioner? 23. None for the parties. Generally, Gopal.
extended. The order of appointment is of 4th of September 2023. Sole arbitrator. 26th of February 2024. The 6 months extension by the arbitrator is on 25th of August 2025. I'm sorry, 26th of February 2025. Yes, but page 57 of my application. Till 25th of August 2025. The 26th, Lordship will kindly. Final arguments. I've prayed for 1 year in my prayer. Grateful. Yes, brother. Grateful.
Your Lordship, I am appearing on behalf of the petitioner, Your Lordship. Here's my affidavit of service. Your Lordship, in this matter, the respondent issued a work order in favor of the petitioner for supply of collar cane. There is a dispute regarding the outstanding bills. This work order contains an arbitration clause. We filed in a section 11 for appointment of arbitrator by an order dated 12 September 2023. Learned 12 September 2023. Arbitrator was appointed, Your Lordship. Thereafter, pleading was completed, Your Lordship, by 24th February 2024. Thereafter, Your Lordship, 6 months extension has been granted by the both parties, and the mandate has set to expired on 23rd August 2025. The proceeding stage is stage of the evidence. Claimant witness number 1 cross-examination is going on.
Lord, I beg to appear for the respondent. My lord, only one point, my lord, I wish to take today before your lordship. My lord, I find, my lord, a constituted attorney of the petitioner. My lord, the petitioner is a sole proprietorship firm. My lord, a constituted attorney has affirmed. My lord, that too, I don't find it before the High Court's oath commissioner. It has been notarized in Alipur Police Court, my lord. My only point is whether I don't have a point. Your lordship will kindly do not record my concession in the order, my lord, because my concession, your lordship will kindly extend. Let it be a court's order. I have instructions, my lord, to oppose on this point. However, your lordship will kindly, my lord, extend it, my lord. Let it be a court's order, my lord.
I- 25, 26. Affidavit of service. Mandate. 6 months mandate. 6 months. First one.
In both the matters, your lordship will kindly not record.
6 months extension before the arbitrator.
Oh, that we have.
29A3.
Oh, that was extended, my lord. That was extended.
সেটা রেকর্ড করছে Five. Evidence, your lordship. For 1 year.
Owned by a constituted attorney of the sole proprietorship firm, my lord, and my lord, before a notary public and not before the oath commission of the High Court.
Six arbitration compositely is going on. 2 file in commercial division and 4 in commercial. Two.
27. Monthly set not 27. My lord, I appear for the petitioner. My lord, I need 1 week's time to serve and come back. Respondents, my lord. The advocate is there who is appearing, so I'll serve upon the advocate. Much obliged, my lord.
May it please your lordship, my lord. This is my application under section 29A, my lord. My lord, the appointment was made by this court in March 2023. 23rd March 2023. Lordship will find it on page 80 of my application. And my lord, thereafter, my lord, the pleadings were completed on 3rd August 2022. And then thereafter, my lord, the 6-month consent was given by both parties on 18th June 2024. And my lord, this is the second application under section 29A, the first 2024. My lord, on 20th December 2024, the first extension was allowed by an order, my lord, 20th December 2024. 2024, my lord, for a period of 8 months. I'm sorry, my lord. First extension. My lord, the mandate was expiring on 7th October 2025. And my lord, this application has been filed on 26th September 2025, seeking 6 months extension, my lord. My lord, the respondent is arguing the matter, my lord's final arguments of the respondent, my lord. We've completed, we'll be replying shortly, my lord.
Lord, with my lord's leave, something we should tell your lordship before your lordship passes the order. We had gone, my lord, filed an application under section 29A before the learned commercial court at Rajarhat. No, that has been dismissed because the order of appointment is from here. And dismissed. No, please see the order. No, I'll just show the order. Then, my lord, whatever your lordship feels. My lord, is this the condition? Lord, please have a look at the order. No, my lord, there is. Now, I'll tell your lordship, my lord, what had happened. There is a reported judgment of this honorable court, which my lord said that all section 29A applications must be filed before the High Court because on the reasoning. Yes. And then, my lord, there is a order of the Honorable Supreme Court, which is, my lord, last year or this year, which says doesn't take the reasoning into, has said that you go court of original jurisdiction. Now, my lord, we filed this application before the district court, which has jurisdiction. And, my lord, the reasoning is in the context of the present case, second case. No, the learned judge says that I don't have jurisdiction to entertain. Somebody also told me that your lordship is entertaining applications where, my lord, initial appointment is by the High Court. No, that's not correct. I agree. Lord, I humbly agree. Please dismiss my, or should I withdraw it? I'll withdraw it. No, I'll withdraw it. Lord, may I only have this indulgence if your lordship says with liberty to pursue remedies elsewhere? Well, I had argued the matter before Justice Boschak, and we're quite disappointed when the Supreme Court judgment came because it's only one page, doesn't take into account. Yes. If their lordships, my lord, yes, once they consider and they decide, my lord, we don't feel disappointment, but just one page. Yes. And somehow you feel that perhaps if, my lord, all logic is, my lord, placed before the Supreme Court, we could persuade just an order, just an order in court possibly. The question, yes, yes. In fact, my lord, this logic was first given by the Bombay High Court and then by the Delhi High Court. Yes. And then we cited that. I think so, my lord. In fact, Justice Bosak's judgment was in this very courtroom during COVID. Grateful, my lord. 227.
For the respondent.
My lord, in this matter, my item number 29, Mr. Omarish Bagh, Advocate Omarish Bagh is appearing in this matter for the petitioner, my lord. He is, due to his critical health issues, he couldn't come to the court, my lord. And he instructed me, he hopes he will not be able to come to the court in this week, my lord. Kindly adjourn for the matter for the week. Grateful, my lord. Madam, item number 198. In that matter also, this Advocate Omarish Bagh.
196.
196 and 198. 196.
My lord, advocate record is ill, my lord.
For the respondent, my lord.
My lord, advocate record is ill, my lord. I am taken not this week, my lord.
My lord, it will appear next Monday.
Not this week, my lord.
I'm good. Yes.
Item 31. I appear for the respondent, my learned friend, section 34 application.
34 and 36 lordship both are there.
My lord, on the last occasion, they said that there is a settlement. We said there is none. I have taken instructions, no settlement. I'm ready to.
Lordship, this is the last instruction they have received. Lordship, we have given them an email on 15
My
September.
lord, this is just to linger the matter. I have instructions, no settlement, my lord. I'm ready to do the matter, my lord. Kindly, my lord, take up the matter. Yes, my lord.
Lordship, but Lordship, I am instructions, Lordship, that talks of settlement is going on, Lordship. It gives.
I'm saying, Lordship can record it.
Lordship kindly gives fortnight time, Lordship. I will take proper instructions and then come back, Lordship.
Well, 1 week, my lord, because the section 34 is not maintainable, my lord.
Lordship.
Yes, yes, Lordship can record. Yes, my lord. Well, both the matters, my lord, yes, yes. 31 and 32.
30. Lordship.
Yes.
Lordship.
Manaki. No, but no, Lordship keeps it next week, my lord. My lord, Lordship will give both the AP numbers in the combined order then. My lord. First is 34, next is 36 2, my lord. Grateful. My lord.
Next. 33.
Happy for the respondent number 1. I appear for the respondent number 1.
I'm for that. I appear for the respondent number 2.
I'm for the petition. Yeah. Pratik Mukherjee was coming, my lord. Mr. Pratik Mukherjee was coming.
My lord takes it up on Monday. There's section 34 without without a stay, my lord, they seek for unconditional stay.
34 and
Lord, this is an application under section 36(2). Lord, I am praying for unconditional stay of the award on the grounds of fraud. Lord, if your lordship looks into the records, Lord, only I seek to file a supplementary affidavit to bring on record the forged documents. Leave may be granted to me. In the meantime, my lord, I shall bring on Monday. Great.
My lord, I appear on behalf of the respondents.
Your Lordship, on the behalf of the petitioner, I am led by Shukanta Ghosh Advocate and Mr. Shukanta Ghosh Advocate, and I pray for not today, Your Honor.
Lordship, they have not served us with a copy of the application. If you could direct.
Actually, I do not have any.
Stay application.
My Lordship, I do not have any instructions further. I am on behalf of
Obliged.
grateful.
My lord, in this matter, I'm only praying for not today. Mr. Shiv Shankar Banerjee is appearing in this matter. He is on leg before Honorable Chief Justice, my lord.
I appear on behalf of this. Great.
36.
My lord, in item number 36, I'm for the petitioner, my lord. I'm led by Mr. Siddhartha Lahiri, my lord. He's engaged in another court, my lord. I pray for not today, my lord. Grateful.
So item 36, I appear on behalf of the petitioner. So this is my section 36 application.
I am appearing for the respondent, my lord. We are yet to receive the copy of the section 36 application. I just contacted with my client. I did not receive it.
Apologize, I am appearing item 37.
37 ito eta. This is item 37.
So 37, I am appearing for the petitioner.
I'm for the respondent, but we are yet to receive the copy of the 36 application. My client just confirmed me.
Also, we have served, we have also filed the affidavit of service. Very well, Lordship. Grateful.
Grateful, Lordship.
Lordship, in item number 38, I am led by Mr. HON'BLE. He is engaged before court number 25. I am praying for not today. Lordship, only one thing. This is an application under section 34. It has appeared under the heading of section 36. Lordship, I am only praying for not today. There is a delay of. Deeply obliged.
My lord, this is an application under section 34 where I have challenged part of the award. This is, I believe, appearing for the first time. If my
Lordship, I appear for respondent number 1 and 3. We're yet to file our wakalatnama. Your Lordship kindly gives us some time.
My lord, let them, if they wish to, let them file their affidavit also.
Yes, yes. In the meantime, the pleadings may be completed. Yes.
My lord, we are challenging part of the award, not the entire.
1 and 3. Lordship kindly gives a time of 4 weeks.
Great.
May I please, your lord? I'm appearing for the respondent, lord.
Item 40, well, this is that matter which was jointly mentioned yesterday, by Mr. Umesh Prasad Singh, and a senior advocate leading us appearing from Patna High Court. But he was requested to if the matter may be kept on 12th. But am I very same, Lord, if it can be kept on 12th, the council are traveling from outside, they can come down before my lord physically and address my lord.
I am opposing this, my lord. The reason is, lordship, the dispute is of 2012. Initially, award was passed, and subsequently it was set aside and remanded back to the fresh new arbitrator, lordship. And if my lords may kindly see the order dated 29th of April 2024, lordship. The matter pleadings are complete. The matter was posted for hearing, and thereafter it has not been taken up for hearing, my lord.
We are ready to
under the
conduct
garb of the pendency of. I'm so sorry, my lord. My lord, may kindly see the order dated 29 of April 2024. It was posted for further hearing on. Yes, my lord. And thereafter, matter has not been taken up for hearing, lordship. And under the due to pendency of this matter, they are submitting before the execution court that due to pendency, please don't proceed with the execution proceeding, lordship. Difficulty is that.
But on
My lord, I'm ready with the matter. I'm ready for argument,
on
lordship.
12th, my lord, we are ready
If the
with the
learned
matter.
senior has some difficulty, he can join virtually, lordship.
On 12th, my lord, keeps it on 12th, my lord, fixes a specific time.
Every
but
day.
he's going.
My lord.
My lord. Yes.
I understand, my lord. May I point?
12th.
My lord, in that case, may I request that time may be fixed, because I am also traveling from Delhi, lordship. And every time the matter is taken up for hearing, they say.
On that, lord, we have no. Your time is fixed, lord.
The
We
matter
can.
for hearing, my lord.
Two p.
Yes. My lord, matter is very small, lordship. That if my lords may just for a moment see the order dated 26th of February 2024. My lord, order, my lord. 26th of February 2024. May I read, my lord? Second paragraph, the primary submission made by learned counsel appearing for the petitioner's award dated is that the petitioner were not parties before the parties to the arbitration agreement, lordship. I will demonstrate from the record, if my lords may kindly see this, their own pleading and the arbitration clause itself, lordship. They are very much the parties, lordship. 2 p.m., my lord.
Grateful.
My lord, may I request my lord to observe one line, my lord? The execution court may proceed with the execution.
Lord, on this one, I am objecting, my lord. We are objecting on this.
Very well, lord. I will proceed, my lord, on 12th.
Yes,
oblige your lordships.
Well, in this matter, this is my application. Subject to my learned
Appeal for the respondent.
My lord, this is
Section 34 application.
my lord, this is a hearing matter subject to my learned senior friends concurrence, my lord. Affidavits have been exchanged. I'm filing my
Yes,
reply.
affidavit is complete, my lord. The award is for more than 44 crores. My lord, all we want is a hearing.
My lord, any
And let it be fixed if my learned friend.
my,
Yes, why not?
my lord, actually, I'm led by Mr. Abhartosh Mojumdar. He's a senior advocate. My lord, he's just because of some personal difficulties out of station. My lord takes it up any day subject to my lord's kind consideration. My lord, we have secured the amount also. The amount of crores has been secured also.
On that, I'll have to make submissions. Yes, he has secured, but that has not helped me in any way. In any case, the matter has to be heard. I don't want to go into the technicalities and nitty-gritties of it. Yes, yes.
My lord, it was my
my
difficulty. Yes.
My learned friend is in some difficulty.
Yes, Mr. Mojumdar actually is out of station, my lord, because of some difficulty.
Or my learned friend can at least commence the arguments.
My lord, after 17th, if my lord kindly takes it up any day, subject to my lord's kind consideration, my lord will hear it. My lord, appearing for the petitioner, my lord. Abhratosh Mojumdar. First week of December,
As soon as possible.
Man, the first week of December.
First week of December, I think, is too far away.
My lord, after 17th of November, any date, my lord.
Well, the 18th in that case.
18 November. Deeply obliged, my lord.
Millard, may I make one humble submission, Millard? In the monthly list, sometimes the matters take time to get called on. If your lordship kindly accommodates on a particular date.
We'll mention the matter subject to my learned senior friends concurrence. We'll mention the matter if there's. Affidavit in reply file. It's bully the affidavit in reply. Deeply obliged, my lord. Affidavit in reply is filed with my lord. My lord.
Yes, I have the copy. Well, Lord, I was humbly submitting if it could be in the third week of November or something.
December
of the monthly
my lord,
December, which is 3 weeks away.
My lord, we'll mention the matter subject to my learners.
Very well, my lord. We shall mention the matter.
I'm November last week. My lord, I appear for the petitioner, my lord. My lord, this is my application, my lord, seeking my lord's leave to deposit a bank guarantee, my lord, pursuant to an order passed under Section 36 of the Arbitration and Conciliation Act, my lord. My lord, I had preferred a Section 34 and a Section 36 seeking stay of an arbitral award. An order was passed on 19th June 2023, my lord, which is in page 50, directing me to deposit a total sum of rupees 5 crores, out of which, 10 crores, out of which 5 crores was to be deposited by way of a bank guarantee with the registrar of the original site. The order is at page 50, my lord. The relevant direction is at page 51, the very first paragraph. Yes, my lord. We have deposited by way of demand draft, my lord. Yes, my lord. We have deposited the bank guarantee pursuant to this order of 19 June 2023. Thereafter, when it has expired, we had submitted an extended bank guarantee, which is in page 64, my lord. This extended bank guarantee, my lord, was valid till 14th July 2025. Now, my lord, due to certain difficulties with the petitioner company, we were late by 4 days in depositing the bank guarantee. We had, my lord. Yes, my lord. My lord, the fresh bank guarantee is at page 69, my lord. The last bank guarantee expired on 14th July 2025. This bank guarantee, yes, 14th July 2025, my lord. And my lord will find that the fresh bank guarantee, which we have annexed with this application, is of 18th July. There was a slight oversight from our end, and also the letter was thereafter sent by the registry, which was on 15th July, after the expiry, directing us to submit the bank guarantee. We had prepared the fresh bank guarantee, we had tried to deposit it, but my lord, since the earlier bank guarantee, the extended bank guarantee had expired, my lord, we would, my lord, I am praying for my lord's leave and direction, my lord, to enable us to file this bank guarantee.
And we are seeking an extension of the time, my lord. Kindly extends the time. So when put in the bank guarantee, my lord, it is absolutely our fault. We had failed to, my lord, keep on to the date, my lord. At page 60, it is very clear, my lord. It told us, and immediately we have taken steps, my lord. So, my lord, we are seeking that if it could be extended so that the stay can continue, and we are ready to do the matter any day if your lordship fixes it, my lord.
My lord, Mr. Ray is leading me. My lord. My lord, the relief, the prayer portion, my lord, is at page 6. The application, my lord, is IAGA 1, my lord.
Praise A and B, my lord.
Grateful, my lord.
Very grateful. My lord.
Commercial. Both is non-commercial matters. So commercial matter.
Oh, the day after, day after.
Yes, 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 yes. Yes. Last time it was taken up to 1:15 commercial, after 2 o'clock non-commercial.
15,
Oh, after 3 o'clock non-commercial.
3 p.m.
So according to your lordship's
Same procedure. Same procedure.
same can be. So on all days, both matters can be taken. Both matters
Lordship
can.
has to also keep execution one.
Yes,
There are too many execution matters.
especially the new executions.
Fridays, if Lordship gives for execution,
whole
which
day.
it was earlier.
Fridays.
The new executions are very important. Because
Great.
Grateful. My lord.
Small money. Sir, sir, I'm appearing in person, sir. In person, sir. Very small.
My lord, I was appealing for the petitioner, my lord. My lord, this was my application for seeking my lord's leave to submit. My lord, the stay was granted on 19th June 2023. My lord, this is my application under section 36 seeking a stay. My lord, the stay was granted. Yes, my lord. Yes, my lord. We have deposited. We have also made over the bank guarantee. When it expired, we extended it. The extended bank guarantee expired on 14th July. My lord, we have a new bank guarantee on 18th July. My lord, there has been a delay of 4 days, my lord. Due to this delay, my lord, I am unable to submit the bank guarantee with the registry. My lord, this is, my lord, I'm seeking my lord's leave to submit this bank guarantee with the registry. Yes, my lord. Yes. Yes, my lord. My lord, any date my lord fixes, my lord will come in. Any date my lord fixes. Main section 34 ये कर दो। No, no, 350. अच्छा, so 34 आगे चाहिए। I don't know. Yes, my lord. My lord, the first bank guarantee expired. The extended bank guarantee expired on 14th July 2025. My lord, that expired on 14th July 2024. বলবো ডেট ফিক্স করতে
Shall be accepted by the registrar original site and shall be accepted by the registrar original site. With this direction, the present application is disposed of. When is what is the position in the list?
My lord, it is, I believe it is not running in the list. AP 212 of 2023, that is the section 34.
It is running in the list.
Oh, it was run with the GM, my lord. I'm sorry, my lord. I stand corrected. AP 212 of 2023. That is the section 34.
Is disposed of.
My lord, may I just hand over the affidavit of service and
Affidavit of service taken on record. GA disposed of.
grateful, my lord.
Yes, get that supplementary. Supplementary.
Supplementary list. N69 of 2020.
Yes, my lord. And for the judgment letter,
Lordship, I appear for the award holder.
warrant was executed on 24th September 2025. He is surrendering before your honor court in for bail.
Yes, what are you saying?
Oh. Warrant was issued, my lord, against judgment letter 2 on 24th September. He was not in Kolkata since from 12th September. He came back on 30 October and he came to know about this warrant and he coming here and surrendering before your honor court, praying for bail.
Take down.
Lordship, the direction was not complied with. No asset has been filed since that date.
Award letter number. आप हैं महादेव महतो
महादेव मुंदड़ा महादेव मुंदड़ा
महादेव मुंद्रा कितना लोन ले रखा है आपने?
कितना लोन लिया आपने?
लोन होगा 14-15 लाख होगा, 14 लाख होगा।
तो वापस करना है?
हैं?
वापस करिए पैसे।
हाँ करेंगे, थोड़ा प्रॉब्लम है प्रॉपर्टी का, देख रहे हैं, होने के साथ में कर देंगे।
अपना एसेट फाइल करिए आप। Take down this court-wide order dated
Lordship, 24th September 2025.
24th September.
24th September 2025 had issued warrant of arrest against the award dated number 2 Mahadev Mundra. Full stop. The award dated number 2 Mahadev Mundra is present in the court. Full stop. Oath to.
बोलिए, मैं जो बोल रहा हूँ मेरे साथ सब बोलिए।
हाँ बोलिए।
मैं इस मुकदमे
में
मैं जो कुछ भी कहूँगा
सच कहूँगा,
सच के सिवा कुछ नहीं कहूँगा,
सच के सिवाय कुछ नहीं कहूँगा,
कुछ नहीं छुपाऊंगा।
कुछ सिखाऊंगा।
हो गया? Oath is administered. Oath has been administered to him. Full stop. Learned, award dated number 2 undertakes to file affidavit of asset. Full stop. Learned counsel for the award dated number 2 Mahadev Mundra also undertakes to file the affidavit of asset within
2 weeks.
Within 2 weeks.
Lordship, kindly record it as
Warrant
the
of
last
arrest is
chance.
discharged.
Time to file extension of wakalatnama.
Further, the award debtor undertakes to appear before this court as and when required. Full stop.
ऐसे उसमें कुछ रुपया भी भरे।
List this matter after 2 weeks.
One thing, my lord, extension of time to file wakalatnama, please. On last order, my lord, it's 1 week. On 12 December 2024, my lord. The order is passed for 1 week of filing of wakalatnama. Please extend the 1 week time to file my wakalatnama.
It's been a year since that date, Your Lordship.
Since then you have not filed the wakalatnama.
For 1 week time to file or
This is the second warrant issued against him.
second warrant issue against.
Lordship is not filing the affidavit of asset.
What is this? You are appearing for him?
Yes,
What is this?
my lord,
He doesn't take the court seriously.
just like that.
क्या बात है भाई? आपको कोर्ट के लिए कोई रिस्पेक्ट नहीं है?
हमारी तबीयत खराब हो गया था, हम राजस्थान चला गया था। ऐसे हम शुगर के पेशेंट है, तबीयत तो खराब हो गया था।
File it within 2 weeks.
मतलब
Further time of 1 week is granted to the advocate on record for the award data number 2 to file his wakalatnama within a week in the department.
Lordship.
List after 4 weeks. 4 हफ्ते के बाद भाई.
पिताजी का नाम रियाज सिंह जी। रियाज सिंह जी।
Call out the non-commercial matters. एक और है.
Yes. So, Lordship, in this matter, I am appearing on behalf of the awardator. And
Lordship, I am appearing for the award holder.
And on the earlier occasion, the order dated 25th September 2025, this Honorable Court was pleased to issue a warrant against the awardator. And today he is surrendering before this Honorable
ये
Court.
order पे तुम लोग हैं. वो दो. क्या नाम है आपका?
मुन्ना ओझा।
पैसे वापस करिए जो ले रखा आपने.
এটা বাংলা হিন্দিটা বলে বলুন। আমি শপথ পূর্বক বলছি, আমি শপথ করে বলছি, হিন্দি বলতে বলুন, হিন্দি বলে বাংলা আপনি কিসের কোন কথা বলতে চান বলুন। আমি শপথ করে বলছি, এই মামলায় সাক্ষ্য দিতে এসে আমি যা বলবো সত্য বলবো, সত্য বই মিথ্যা বলবো না, কোনো কিছু গোপন করবো না।
Same कर देना. This court-wide order dated 25 September 2025 and issued the warrant of arrest against the award debtor number 1. Full stop. Oath has been administered. Same order कर दो.
46.
Lordship, kindly grant 4 weeks to file the affidavit.
Why
of
4
assets.
weeks?
It's required bid time is required if your Lordship pleases so.
Not at all.
Deeply
2
obliged.
weeks. It's your asset. Why do you need 4 weeks? You don't know your assets.
Needs
You have
some
to find out.
Then
Should do it in 2 days.
deeply obliged.
4 weeks.
And the wakalatnama will be filed, your Lordship, during the course of the day.
Commercial matter, item number 1.
Appearing on behalf of award holder in this matter. Yesterday, my lord, director has to inform the receiver
Yes.
to appear today, my lord. We have intimated the receiver, but difficulty receiver father is ill, my lord, is hospitalized. He needs a 1 week time. He requested me to request the honorable court kindly grant him the 1 week time. He will appear the next week any day.
subject to convenient.
If I am appearing for the award data number 2 and 3, so I have a humble request. I am not standing in the way. My property is being sold. I have offered that should be sold, and whatever money they get, that should be satisfied towards the decree. Now, Lordship, this was the order passed on 25th of July 2018, which your Lordship will find at internal page 3. It has been recorded in the last paragraph that the amount realized by selling my property will be satisfied towards the decree. Now, let them get the money, let them satisfy the award amount. I am only seeking an indulgence. My bank account has been restrained from operation by an order of 12th October 2023. Now the property is being sold. Award was for 1.1 crore. Now they are getting more than after selling the property. Now my account should be made operational. Injunction is operating from 2023. If your Lordship kindly have a look at this order.
After the receiver.
Property has been sold. That is an admitted
After
position.
the receiver files his report.
Your Lordship will consider my prayer after
Only
that.
after the receiver.
Grateful.
At the request of the parties, let this matter be listed after 1 week.
After 1 week, man.
Lordship, I am appearing for the award holder in this matter. Lordship, the award holder number 1 is a company which has gone into liquidation. We had taken direction for the award data number 2, 3, and 4 to file their affidavit of assets. Lordship, that has not been filed till date. And there is an application which has been filed on behalf of the respondent number 3 to stay the warrant of arrest, even without filing the affidavit of assets.
For the award holder, Your Lordship, the award holders are staying outside of India. Award daters are out. They're staying outside of India, US,
So-
Washington.
So
The difficulties of communication. So I'm seeking 4 weeks of time to file.
why?
Uh,
You have already got so much time.
it is required as because the notarial process, they will send the copy through after notarial, then we have to file it. So it will take time, Your Lordship.
What were you doing since July?
So the initial order was of March 2025, then extended in July.
What are you doing since March?
There was a communication gap as because they are staying outside.
So what? Even if they are staying outside, will they take 5 years?
No, Your Lordship, but I'm seeking prayer.
So you're appearing 1 and 3.
1, 3, and 4.
1, 3,
Yeah,
and
2, 3, and 4, Your Lordship. 2, 3, 4. As because
there's no 4 here. 1, 2, 1, 3, 1, 2, and 3 are there.
Lordship, there is a
1, 2,
What-
3.
what-
See the order of 28th March.
one is the company, Your Lordship, that has gone for liquidation. Balakrishnan S. Harur, Pooja Satish Harur, and Nandan Umbarji. I'm for these 3.
Lordship, for on the 20th of March, there was only direction for 1, 2, and 3 to file their
1,
affidavit.
2, and 3.
Yes.
Anybody who has filed it? 4 has filed it.
No, no one has filed.
I'm appearing for all those 3. I'm
You're appearing for everyone.
these 3.
So 1, 2, 3, 4. All you're appearing for.
The company is already in liquidation. So, Your Lordship, only for the
So 2, 3, 4.
2, 3, 4.
And you file it for 2, 3, 4.
I will file it. Kindly grant leave.
You have
for
been
4
taking
weeks.
time since January of 2025. 3rd January, the last order was passed. I mean, the first order.
I know, Your Lordship, it's my
The same council.
default. Same council.
You're.
I'm appearing in behalf of Arnab Datta. I'm his.
What are you doing then? This can't go on like this.
My apologies, Your Lordship. I'm assuring you that I will file within 4 weeks.
The warrant of arrest has been kept in abeyance. We should.
Yes, because they, on the last occasion also, they had undertaken to full.
He is a senior citizen, Your Lordship. That's why.
More reasons to comply with the order of the court.
I will comply, Your Lordship. Kindly grant leave for the last time.
This court-wide order dated. The first order is January, right?
3rd January 2025.
Wide order dated 3rd January 2025 had directed the award debtor number 2, 3, and 4 to file their affidavit of assets by 28th November 2024 and were directed to be personally present on 5th December 2024 for examination. Full stop. And the second order is
2nd
March, 28th March.
March.
The said order was not complied with. This court, again on 28th March 2025, to it, 28th March 2025, noted that the award debtor number 2 is residing in the US and shall be available for examination virtually. Full stop. It was further directed that the award debtors will file their affidavit of assets. Award debtor number 1, 2 shall file their affidavit of assets, and the warrant of arrest was kept in abeyance. Full stop. The said order again was not complied with. After March, it is the
11th July 2025.
Again this court extended the time to file affidavit of asset by a period of 6 weeks on 11th of July 2025. Wide order dated 11th of July 2025. Even today, the award debtor number 1, 2, and 4 have not filed their affidavit of asset and seek further extension of 4 weeks to file their affidavit of assets as directed by this court in its first order dated 3rd of January 2025. Full stop. Fine. Full stop. Learned counsel for the award dated 2, 3, 4 undertakes that he shall file the affidavit of assets within a period of 4 weeks and that this will be last opportunity granted to them. Mr. undertakes to file their affidavit within 4 weeks. Let this matter be listed after 8 weeks.
8 weeks.
Item number 3, I'm
I
appearing for the
appear for the award holder, my lord. My lord, this is an execution relating to an award of 2024. 5th April 2024, my lord, an award is passed. May I just indicate, my lord, why it's appearing as to be mentioned? Because, my lord, in my humble submission, there is sufficient urgency in the matter. My lord, here 5th April 2024, an award is passed in my favor. My clients are home buyers. We had sought to book a flat. The respondent is the developer. Admittedly, the flat was never delivered. The arbitrator grants us a money award, refund of the entire money that we've paid to the developer along with interest. And also, since we had taken out a home loan to fund our purchase of the flat, a mandatory injunction is passed by the learned arbitrator to clear the dues of the bank by the respondent award debtor. This is the totality of the award. I am just an ordinary citizen who had booked a flat and been due by a developer. From 5th April 2024, we then file an execution. No section 34 file, no question of any stay of the award. From that date, we file the execution. The execution case has been taken up several times over. On every occasion, what the award debtor here does, and my submission is this is a recalcitrant litigant. Every day the matter appears before this honorable court, a token amount of 1 lakh, a token amount of 2 lakhs is made payment of a total awarded sum, which is in excess of 20 lakhs, taking the bank's dues as well. Token amounts are paid. On the last order, I will not, can the orders speak for themselves every time this has happened. Last occasion, will kindly take 4th August 2025 order. A categoric submission was made that a particular amount would be paid by the award debtor, 5,56,000. Will kindly see 4th August. An amount of rupees 5,56,000 shall be paid by the award debtor within 20th October 2025. Not been paid. Blatant disregard, repeated orders have been passed for them to try and settle. They never communicate with my client apart from when the matter is in the court and in the list on that date. On that day, they will make a token payment. And this order, has been blatantly not complied with. An order of court. I am humbly beseeching today to exercise powers to direct their directors. The respondent is a company. I am praying for an order, directing the personal presence of the directors. Let them be examined. Let them file their affidavit of assets. And whatever consequences follow will follow.
Managing director was supposed to be present today. Where is he?
He's present. My lord, may I indicate two things, my lord? The exact facts.
Why is he? Where is he?
He's present.
Why is he not making the payment?
My lord, may I just indicate the facts? Whatever has been placed.
Forget the facts. You just comply with the order.
I am trying, my lord. That is why from the very beginning when this
what money have you got today?
Today I do not have. My lord gives me 7 days time. By next Tuesday, the entire 5 lakhs would be paid. That I have spoken to them. My lord, in the meantime, because of the festivities and everything, they had to shell out bonuses. They were in some difficulty. My lord, they will pay out
5,56,000 by Tuesday.
Tuesday, my lord.
By Tuesday.
By Tuesday.
We'll have Tuesday we'll have it.
Absolutely.
Not today. Keep it for Tuesday.
The issue which has been drawn to my lord. That
forget about the issue. First, you make the payment, then I'll hear you.
Then I'll come.
Otherwise, don't even open your mouth.
Deeply.
Deeply. I shall come back.
Deeply.
पैसे दीजिए.
We've paid over 8 lakhs, my lord. We'll pay the remaining.
I'm not listening to you. I don't want to hear a word. First, you comply with the order which has been passed by this court. Then I will hear you.
Very well.
Okay.
My lord, I shall
have
pay,
a footing. Then we'll hear you.
Very well.
Deeply.
Tuesday.
I'm appearing for the award holder, my lord.
Lord, I am appearing for the judgment debtor, item number 4, my lord, for compliance. My lord, the matter has been settled by and between the parties, my lord, for an amount of 25 lakhs. And my lord, my client has paid the entire amount in 3 monthly installment in terms of the last order of penalty.
We have received, my lord.
My only one thing, my lord, there are 2 interim orders passed in this matter in terms of prayer B and D of the tabular statement, my injunction and the receivable within the only possession of the 3 properties owned by my client, my lord. My lord, by these 2 orders, my lord, let these orders can be vacated, my lord. Ninth April and 15 January.
All right. Take down. Both of you are advocate on record, right?
Yes, my lord.
Learned counsel for the parties submit that the present matter is settled. Full stop. Is there any settlement agreement?
No.
All right.
We have transferred the amount in 3 monthly installments, 8 lakhs,
Has
8
been
lakhs and
settled.
9 lakhs.
Learned counsel for the respondent says that, learned counsel for the respondent says that he has paid the settlement amount of rupees 25 lakhs in 3 installments dated 1/7/2025, 1/8/2025 and 1/9/2025. Full stop. The said fact is accepted by the learned counsel for the petitioner, who states that the settlement amount has been paid and the present matter stands and the award stands complied with. Full stop. In view of the said fact, the present petition is disposed of. All interim orders stand vacated. Oh, application stands disposed of. Present application stands disposed. All interim order stands vacated.
Grateful.
Much obliged.
Lord, I appear on behalf of the respondent number 1 and 2. Lord, I'm opposing this application. Just two things.
What application is this?
Lord, so this is my
2
application.
points I
The
have,
post
if
award
I may
section 9.
indicate, Lord. First, Lord, possibly this post award section 9 application is not maintainable because they are asking for execution of an award which has been challenged and section 34 application is pending. This is number 1. Number 2, Lord, their entire claim is relating to payment of municipal tax, and that claim arose, my lord, after, my lord, the reference was made and the learned arbitrator passed the award. Therefore, this is a new cause of action, and for that a section 21 notice has to be issued. Straightway they can't come. These are the 2 points I have on maintainability. Let my learned friend address, my lord, then I would address, my lord.
Your Lordship, perhaps the objection that my learned senior friend is taking right now would not lie, because my learned senior friend has already taken these points before the prior single judge. We went up in appeal. The division bench has ruled in our favor. In fact, the division bench has made an observation that all that remains to be done is for the receiver's report to be considered and the liabilities to be apportioned, which the receiver has done as per prior directions, and I shall place the relevant orders and pages before your Lordship. If I may give a brief factual background, your Lordship, what had happened was this is pertaining to a property which was developed by a partnership firm of 5 brothers. I am representing 2 of them, and then my learned senior friend is representing 2 other brothers, and there's one more with whom we have settled. The brother with whom we have settled the matter initially had filed had sent a section 21 notice and initiated arbitral proceedings before. Now, during the pendency of the arbitral proceedings, your Lordship.
Yes, sir.
Yes.
So this matter has been substantially heard or what?
It was, yes, affidavit has been filed. Previously, it was heard by Justice Shobhoshachi Bhattacharya. Matter went up in appeal. Appeal court passed an order. Then again, it had gone to Justice Shompa Sharkar, who was having the determination. She has heard it, Lord, substantially.
It's not a part-heard matter?
No, it's not a part-heard. Lordship can take it up.
Yes.
Your Lordship, during the pendency of the dispute between the parties, the property has at all material times been under the possession and control of a receiver. Now, prior to this, the receiver, although was in possession and control of the property, he was not paying the due taxes to the municipal corporation, and a huge substantial amount had accumulated. In 2020, we received a letter of intimation from the KMC stating that a total due of around 1.89 crores along with penalty and interest was due and pending, and they had come up with a particular waiver scheme, tax waiver scheme. We were intimated that if we were to avail of the scheme within a particular period, stipulated period within a particular date, then the tax, the penalty component and the interest component would be waived, and the total demand was around only rupees 44 lakhs. So the benefit that we would be availing of would be around 1.5 crores. In this context, your Lordship, we had filed a section 9 before this Honorable Court, seeking
for the receiver to be directed to pay the particular amount from the tail of the receiver, because the receiver was in control. Now, for whatever reason, the particular matter was not taken up by this honorable court, by the single judge at the time, and we decided to take advantage of the scheme for the benefit of all the partners, because as per the partnership deed, the 5 brothers are to share all assets and liabilities equally, 1/5 share each.
So the 5 brothers have got into some development agreement. What is it?
Yes, it was a partnership deed based on which we were supposed to develop the property at the particular 10B Shakespeare Sarani and then let it out for in order to commercially exploit the property and let it out to other people.
The property belongs to all the 5 brothers?
Yes.
They came together to develop the property
Yes.
for commercial purpose.
Yes.
Right?
Right.
They are the lessees, my lord.
We are also the lessees.
It's a lease agreement.
It was a lease agreement. We take up.
999.
Yes. We were to develop the property and then we were supposed to retain certain portions for ourselves and let out the remaining portions and enjoy the rent that is collected from each of them.
And lesser is who? KMDA, who is the lesser? Who's the lesser?
The lady was the owner.
Yes.
Owner was the lady.
5 brothers entered into an agreement. Only business was to construct, develop, and to let it out. And there was an additional agreement. Each brothers would take 1 flat, retain it for their own purpose. Now, the dispute is after 1990.
And the contract is between all the 5 brothers? What is
the partnership deed is between the
partnership is between the 5 brothers?
Yes, as well as we had taken it from the
first the lease agreement, then the partnership agreement between the 5 brothers. Certain terms and conditions were there. The arbitration clause was there, my lord. Now, since 2 of the partners, my lord, who are being represented by my learned friend, did not comply with the terms, my lord, inducted certain persons, my lord. One of the partners chose to refer the dispute to arbitration. Section 11 application was filed because there was an arbitration clause. This honorable court appointed an arbitrator. Then arbitrator proceeded with, my lord, finally passed an award. Now, this issue of municipal tax was an issue before the learned arbitrator, and he has passed an award on this. Our contentions, we were the opposing, my lord. We were the respondents before the learned arbitrator. We had a counterclaim that was rejected, my lord. Claimant's claim was rejected. Only thing, my lord, since there are several occupants, and our contention was those occupants were inducted by them, what the learned arbitrator did in his award, he directed to make payment relating to the alleged payment of municipal tax, and he enhanced the rent. Now, regarding that enhancement, my lord, since they had inducted, they preferred a Section 34 application, challenging that part, because the enhancement really affects them. Now, we challenged the entire award. We filed a 34, and the other brother, with whom my lord dispute had been settled, my lord, he also filed a 34. Now, presently, 2 Section 34 applications are pending, one filed by us, 2 of the partners, 2 brothers, and another 34 filed by them. Now, that was an issue. Now, in that regard, my lord, they made payments, municipal taxes, my lord, they paid. They paid because they are in actual control. So, and we stay in Delhi. We didn't get anything. That was the contention before the learned arbitrator also. So we said, why should we be directed to pay when we don't get anything out of it? You have inducted, municipal tax had gone up all because of you. So till the time this issue is finally decided, it is you. Since you were in control, you have to pay. So that was the scope. Then they started paying, and because there was a scheme introduced by the Kolkata Municipal Corporation, they availed it, they paid it, certain excess money was there, they made a post-award Section 9 application. Now, that post-award Section 9 application, there was a prayer for a direction upon the receiver to pay off. What the learned trial judge did, first time when the Section 9 application came up, he said some amount has to be paid. Learned receiver was asked, and he was directed to pay a certain sum of money, whatever he had, because receiver who was appointed, on a Section 9 application, he was directed to pay certain statutory outgoings, electricities and all that, because there was dispute between the partners. So he paid certain sum of money, and the learned single judge, in addition thereto, directed that the excess amount which is required to be paid, that has to be paid by the partners in proportionate to the ratio, proportionately. So we challenged that. Appellate court said, there is some substance in the argument, because 34 is pending, and that's an issue, because that part is state relating to the direction on the parties to make payment. Some amount has been paid, no problem. We also said no problem. But we can't pay it out of our own pocket, because that's an issue. You are in control, you have to pay it for the time being. After that, matter came back before the single judge. Single judge heard it. And what the division bench did, my lord, I forgot to point out. Division bench said since the 34 is pending, that application post-award section 9 on which the first order was passed directing the receiver to pay and the balance amount to be paid proportionately, said that this has to be heard with the 34 application, either independently or with the 34. The court is incisive of the matter. So finally, the single judge said, no, we can't entertain you. We can't pass an order because 34 is pending. And he had made certain observations. Against that, my lord, they preferred an appeal. Appellate court set aside the order, but again observed that there was a receiver's report whereby receiver, my lord, apportioned it and said, this is what you have to pay. That has been challenged. An exception to the report has been made. That has to be heard. And secondly, yet again, the division bench said that the application post-award, the present application, either it can be heard independently or with the 34. In that context, my lord, affidavits were exchanged. The matter has now come up before your lordship, and before the my lord, prior to my lord getting the determination when Justice Shampa Sharka was having determination, this point arose, which was not urged before the single bench or before the division bench, that this is a subsequent cause of action. From the claim what would appear after the learned arbitrator entered into reference, passed the award, this claim came. So where is the scope of adjudication, which was never urged before the division bench? So first point is the execution stage. When 34 is pending, if finally it is decided, so then everything is decided. Nothing remains in the 34. And a section.
Can you allow me to first place my application?
I'm sorry.
I haven't said anything.
I want to hear it. Don't worry that I'm getting prejudiced. I'm just trying to understand what exactly is.
And when section 9 is saying it is prior, during, and after, but relating to the reference, execution is not permissible in section 9 because 34 is pending. It's not a deemed decree under 36. You can't execute. Under the garb of section 9, you can't execute a decree. That's one of the point. And second point is all relating to a new claim, post-award. So where is the scope of adjudication and direction? That was the court's prima facie.
You know his argument.
Yes. Your lordship, the same argument my learned senior friend has made on at least three prior occasions when I have been present. And all those occasions, your lordship, the learned judges have held against my learned senior friend. Before the single bench, before the learned single bench, Justice Shobhashachi Bhattacharya was presiding, had the relevant determination at the relevant point of time. He had ruled in my favor. He had only refused to grant the relief on a technical point, stating that a prior order of the division bench, presided over by Justice I.P. Mukherjee, that had a particular line which says that it would be stayed for the time being. The learned single judge ignored the phrase "for the time being" and deemed that since the stay was still in operation, he cannot grant the relief. From that order, I do prefer an appeal before the learned honorable division bench, and the honorable division bench has clearly stated. Your lordship will kindly take up the order of the honorable division bench. That will make things clear.
Let's see the first single bench.
Yes. Then, your lordship, I would like to show you the order of Justice Devanshu Boshak, dated 5th March 2021 at page 179, volume 2 of my application.
Volume 2 then.
Because that was the first.
How many volumes?
Your lordship, the application itself is 2 volumes. And supplementary affidavit, there are more volumes, but I'm not referring to that right now.
Which order is this?
Your lordship, this is the order of Justice Devanshu Boshak. This was the original section 9 that I had filed asking for direction upon the receiver to take advantage of the scheme. In that context, your lordship will kindly see the order that was passed by Justice Boshak. Your lordship will kindly straight away come to page 181. The order starts at page 179, volume 2.
181.
Yes, your lordship will straight away come to page 181, second paragraph. The court is informed. Your lordship will kindly come to page 180 first. Page 180.
Yes.
Your lordship, the second paragraph.
Yes.
The fact that the immovable property concerned is the subject matter of the arbitration is not disputed. The shares of the parties in respect of such immovable property are not disputed, which is 1/5 each. Then your lordship will skip 2 paragraphs and come to the line in between. It is an admitted position that the immovable property concerned raked up a large corporation tax liability. Thereafter, at page 181, your lordship will kindly turn over. Second paragraph. The court is informed that the petitioners paid the entire corporation tax liability of rupees 44,42,123 to the corporation within February 28, 2021 to avail of the benefits of the waiver scheme of the KMC. In such, the court is informed the receiver is in season of a sum of rupees 25 lakhs. In such circumstances, it would be appropriate to direct the learned receiver to disburse a sum of rupees 20 lakhs out of the funds lying with him to the petitioners towards pro tanto satisfaction of the share of the claim of the petitioners on account of corporation tax liability of rupees 44 lakhs 42,123, which the receiver has paid. Thereafter, the respondents will pay the corporation tax of rupees 44 lakhs 42,123 in accordance with their declared share, which is 1/5. The respondent will pay the shortfall to the petitioner if there be any. The petitioners are at liberty to execute the shortfall if not paid by the respondent within the period of 4 weeks from date. So here itself, my learned friend, senior friend, is taking the point of execution. I was given liberty because this order was granted by Justice Boshak on the principles of restitution, because my prayers were in the nature of asking the receiver, because that was maintainable. In order to maintain the subject matter of the arbitration, which is the property, I had sought for directions upon the receiver to avail of the corporation tax liabilities, and my learned friends have benefited from it. Instead of paying 1.89 crores, he is having to pay his share of 44 lakhs. Now, thereafter, your lordship will kindly take the order of the division bench because they had challenged this order. That order, your lordship, is at page 182, order dated 16th April 2021. Your lordship will kindly come to page 183 at the top. It is nobody's case that the money was not paid to the corporation not on account of the property in question. Therefore, we see no reason to stay that part of the order directing the receiver to disburse rupees 20 lakhs out of his funds in his hands to Mr. Bose's client. Your lordship.
Where are you reading?
Your lordship, at the top, the first paragraph. It is nobody's case that the money was not paid to the corporation or not on account of the property in question. Therefore, we see no reason to stay that part of the order directing the receiver to disburse rupees 20 lakhs out of the funds in his hands to Mr. Bose's client as ad hoc payment towards the corporation tax liability of 44 lakhs 42,123. There is some substance in the contention of Mr. Dev. We direct the receiver. Your lordship, the division bench categorically gives these directions upon the receiver. We direct the receiver to scrutinize the bills and receipts with respect to the payment of rupees 44 lakhs 42,123 and to apportion liability for this amount of the parties on the basis of their shareholding, which is 1/5. The receiver shall prepare a report with which should be annexed a statement of account reflecting the figure and also the liability of each party, taking into account the reimbursement of rupees 20 lakhs made to Mr. Bose's clients in terms of this order. Receiver shall file a report on such and such. The direction in the impugned order upon Mr. Ghosh's client and Mr. Dev's client to pay shortfall to the petitioner is stayed for the time being. This was the stay order that was in question. The connected application is disposed of. All observations are tentative. Directions contained in the order are interim in nature, prejudice to the rights of the parties without prejudice in section 34 application. Now, your lordship, based on this order, the receiver has scrutinized the bills. Mr. Dev was present personally. At that point, I was not there. Arguments were made. The originals of all the bills, the KMC tax, that we have the no objection certificate, everything was produced before the receiver. The receiver has scrutinized each and every original document and has prepared a report. Your lordship will kindly find that report at page 187, volume 2. So, your lordship, 3 essential directions. First was to pay the...
There is another.
It is after the report.
Prior to this, after this.
I shall place that order. 3 essential directions. First, pro tanto satisfaction, rupees 20 lakhs, which has admittedly been paid to me. Second, to scrutinize the bills, which the receiver has done, and apportion the liability as per the declared shares, admitted declared shares of each of the partners, which is 1/5. Now, your lordship will straight away come to paragraph 4 at page 189. The 6th line from the bottom of paragraph 4. The shareholding. Your lordship has found 189, paragraph 4. Your Lordship has come to
Paragraph 5, 4.
4. Sixth line from the bottom of paragraph 4.
Each partner is having 1/5.
The shareholding of the. Your Lordship is there. The shareholding of the partners is admitted. Each partner is having 1/5 share in the partnership firm. The Honorable Division Bench has also laid down the method of apportioning the liability by scrutinizing the bills and receipts with respect to the payment of 44 lakhs. All bills, receipts, and no outstanding is issued by KMC are filed before me.
So there's
Thereafter,
no
Your Lordship.
outstanding as of that date.
Sorry, Your Lordship.
So there's no outstanding.
No. Whatever outstanding that was there at that point of time, our demand was issued to us. 1.89 crores were outstanding. We paid within the due date. We avail of the benefit. We pay 44 lakhs. Thereafter, another 3 lakhs during the interregnum period had accrued. That 3 lakhs also we had paid. But since the order of the Honorable Division Bench was apropos the sum of 44 lakhs and not 47 lakhs, the learned receiver has restrained himself to the amount of 44 lakhs, which is recorded thereafter at paragraph 12, page 191. Paragraph 10. At page 191, Your Lordship will find, along with the written notes filed by Ms. Rakesh and Kamal Jindal, who are my clients, a calculation sheet is attached showing the liability of each partner. It is stated that a total sum of 47 lakhs 50,000 and odd has been paid by Rakesh and Kamal Kumar Jindal to KMC and such and such. Thereafter, Your Lordship will come to paragraph 11. The learned receiver is saying that he has paid the sum of rupees 20 lakhs. Paragraph 12, in order to comply with the further direction of the Honorable Appeal Court, I have scrutinized the bills and receipts of KMC with respect to payment of 44 lakhs 42,000 as directed by the Honorable Court. None of the parties contended that such payments were not made. And they are not even denying today that we have not made the amount. It is an admitted position that such payments were not made to the Kolkata Municipal Corporation by Rakesh and Kamal Jindal. I find that total payment made to KMC is 47 lakhs. A no due certificate is also issued. I am directed to apportion liability among the partners of a sum of 44 lakhs. So he apportions this amount. Paragraph 13, there are 5 partners, each having 1/5 share. So the liability of each partner is such and such, comes to around rupees 8,88,424. I have already paid us. Lordship, the next page. I have already paid paid rupees 20 lakhs to Rakesh and Kamal Jindal from the fund lying with me. As such, the KMC liability stands at 24 lakhs 42,123. This amount now has to be divided among the 5 partners. Accordingly, the share of each partner in the said sum of 24 lakhs is rupees 4 lakhs 88,424. Rakesh and Kamal Jindal have paid the entire sum of 44 lakhs, which includes the share of 4 lakhs 88,424 into 2, which is 9 lakhs 76,848. Therefore, balance sum of 14 lakhs has to be divided amongst Anup, Sunil, and Ashok Jindal in equal shares. After apportionment, the liability and after taking into account the payment of 20 lakhs, the said 3 partners' liability is rupees 4 lakh 88,424 each. And the calculation sheet is in the next page at page 193. So the learned receiver has categorically followed the direction given by the Honorable Division Bench. Thereafter, Your Lordship, despite the receiver's report being filed, my learned senior friends' clients, they do not disburse the amount. Instead, they file an exception to the report before the Honorable Division Bench. In that context, Your Lordship will kindly come to the order of the Honorable Division Bench dated 28 January 2022 at page 268, volume 2. Starts at page 268. Your Lordship will come to page 269. In the middle, it states that the application IAGA number 5 of 2022 has been taken out by the appellants, taking exception to the report filed by the receiver. Thereafter, skipping one paragraph, section 34 applications are pending in this court challenging the award. A subject matter of the award is the municipal tax due and payable by the partnership firm, including.
Where are you reading? Just go slow, please.
Your Lordship, the bottom of that page, page 269.
Yes.
Yes. This is the portion that my learned senior friend relies on. It states that section 34 applications are pending in the court challenging the award. subject matter of the award is the municipal tax due and payable by the partnership firm, including fixation of the liability of the firm and apportionment thereof among the partners. Thereafter, at page 270, we are of the opinion that the subject matters of these two applications can be properly decided in the forum where the final award is under consideration. In those circumstances, we dispose of each of these two applications on the basis of the observations made above, giving leave to the applicants to urge the same grounds as made in these applications by way of an application or otherwise before the said forum. GA3, Your Lordship, was my application which was seeking for the disbursal of the amount before the division bench as well. So in this backdrop, Your Lordship, I had filed a fresh post-award application before this Honorable Court, which is the present AP number 117 of 2022, which is this application, this Section 9 application, pursuant to the leave given by the division bench. Now, when I move this application before the learned single bench, Justice Bhattacharya, like I had previously submitted, he says that the stay portion is still operational. Therefore, I cannot interfere. Prima facie, he has made observations in my favor. Thereafter, he says that because of the stay portion, I cannot interfere, so I will not interfere. I prefer an appeal from that order of Justice Shobhashachi Bhattacharya before the division bench, and the Honorable Division Bench has finally passed an order in my favor, stating that the learned single bench did not consider the receiver's report. All that is, it is not in dispute that the amounts cannot be paid, that the liability, apportionment of liability cannot be done or has not been done. And all that remains to be done for the learned single judge is to make that payment after considering the receiver's report. And my learned single friend, senior friend, was given the liberty to file an exception, if at all, which they have not, at least so far. Your Lordship will kindly take the last order of the Honorable Division Bench, dated 5th November 2024. Your Lordship has the order, 5th November 2024. Your Lordship should have it in your Lordship's record.
I'm sorry, Millard, it's in
Otherwise, I can hand
paper
it
book,
over.
volume 7, Millard.
Oh,
Page 10.
I have also annexed in my supplementary affidavit paper book.
Supplementary paper book to them, volume.
It's here.
Lordship has got it.
Lordship has.
Yes, sir. This appeal is arising out of the order dated 2nd July. That's the one?
Yes, Your Lordship. The order dated 2nd July 2024 was the one that was passed by the learned single judge, Honorable Single Judge. The award has several components. There are several proceedings between the parties. However, for the present purpose, we may refer to the order dated order passed by a coordinate bench on 16th April 2021, Your Lordship, which I had referred to, giving the directions upon the receiver, where the Honorable Division Bench has made the following observations. These were the observations that I had placed. Thereafter, Your Lordship would kindly come to page 4, internal page 4 of the order.
We'll hear you tomorrow.
Your Lordship, may I kindly just place this order? That's all. Your Lordship, very well.
Day after tomorrow.
Very well.
Tomorrow is holiday.
Tomorrow. Yep.
Lordship.
Grateful, Your Lordship.